Page number 9 of this appeal, I have given the tabular presentation of this 11 crore 57 lakhs, wherein it is clearly visible that the amount of 20,15,629 was remitted to the principals.
When?
As and when it was received, my notes, because during the conference of the period, I was receiving the amount of.
No, look at your synopsis at page 3.
Yes, Manoj.
First paragraph itself, yes.
That undisputed facts are that appellant had collected an amount of 35,90,811 as service tax on behalf of principals. That out of said amount, an amount of 20,15,629 was remitted to the principals as of date of such was made on the premises of the appellant, and balance amount of 15,75,182 was yet to be remitted to the principals, which was put on hold as the respondent department proceeded to demand tax from the appellant.
You are yourself admitting that there was yet to be certain remittances to be made.
I know the date when the search happened, the remittances which are yet to be remitted as of that date, there was some accounting reconciliations going on. We have some money with us which is to be remitted at the month end. So it is that amount minus which was yet to be remitted. It was not that amount which was being compiled by us over a period of time yet to be remitted to the principals.
Is there any material that you have produced before the authorities of the principals having received it?
But these are only the remittance registers wherein the check numbers are coming and the date of check is also coming. And it has not been disputed. It is a case that only part amount has been declared.
In synopsis, we come to page 3.
Yes.
The undisputed facts are that the appellant had collected an amount of rupees 35 lakhs as service tax on behalf of the principals. That out of the said amount, an amount of rupees 20 lakhs was remitted to the principals, as on date of search was made in the premises of the appellant. And that a balance amount of rupees 15,75,182 was yet to be remitted to the principals. He said it was paid. Even here, he's saying it was yet to be remitted to the principals, which they put on hold as the respondent department proceeded to demand tax from the appellant. That is the ground. Even in paragraph 3, Lordships have read paragraph 4 of the impugned order. The Lordship see paragraph 3 in the 3.
So paragraph 3 was the portion that I have just asked him to read.
The Lordship had read 4.
No, paragraph 3. Just now he read this page 3 only. Synopsis page 3, the first paragraph. He says that this is the current payment that he has to be made, but by that time, since the search was already done, so the remittances could not be made. This is something current payment that. Okay. Yes.
The learned AR submitted if the appellant was not rendering any service to the client. They should not have collected the service tax in the first place. Further, they have not provided any evidence before the adjudicating authority to the effect that they have remitted the entire amount of service tax collected by them to the principal. This also gets clarified. This also is the finding. This also gets clarified with the fact that rupees 15.75 lakh was not remitted and is being shown as payable on to the principal in their books of account even after 4 years from the date of show cause notice. He further submitted even their claim that they have remitted this amount to the principal. There is no evidence forthcoming from the principal that the principal has paid the service tax to the revenue. Therefore, in terms of section 74A, 2 and 3, the adjudicating authority was correct in confirming the demand along with interest and penalty. In fact, there was some liberty in which the Lordship sees the second issue as well. They didn't consider evidence and he was still demanding back. Even on that, it should have been adopted in favor of the department. However, not in spite of them not producing evidence, was demanded back. They've already got a benefit not by the same one.
What is there to interfere?
My notes, I would like to highlight, bring your attention towards page 122. That is my reply to Shoku's notice.
Page
122, annexure 6. May I read my notes?
Yes.
Second line my notes. what I have pleaded before the respondent department initially is that the actual amount of service tax collected during the relevant period was 35,90,811. Out of this amount, an amount of 20,15,629 was remitted to the principals, and the balance amount was kept on hold. That the department pointed out the tax liability on the notice. This fact was also brought out in the statement dated 27th of September 2010, deposed by the managing director of the company before superintendent of service tax.
Why was it kept in hold?
Because my lord, the department came, searched my premises and asked me to pay this money entirely to the department.
Yes,
I was under an agreement obliged to remit it to the principals.
one and the same thing.
That's what my lords, I have said.
Either it would have been paid by the principal, or since it has been collected by you, you could have paid it.
My lord, what I was being held by me at that point of time, I offered that I will pay entirely this amount to the department instead of to the principals.
Yes.
But whatever has been remitted to the principals, that would be like asking me to do the impossible if I have.
Why was it not paid for the last 4 years?
Because my lords, the matter was in sub judice and it was an accounting entry which was kept pending.
How do you say for 4 years?
My lord,
When was the search conducted?
2010,
What is the period of payment? 2006-7.
6-7 to 9-10.
Yes.
The part period contains initial periods it was paid, which amounts to 20 lakh rupees, it was paid. As on the date of such amount, yet to be remitted was 15,75,000, which
So for the period between 2006-7 to 9-10.
Pardon, my lords?
For the period 2006-7 and to the 9-10.
It was not entirely to that payment, my lords, it was the current payment as in that date, which was yet, had the such not been collected, this amount would have also been remitted to the principals. And that's what my lords may kindly have the entire order passed by the sister.
Difficult in that circumstances to interfere.
My lords may kindly have paid 151 for the moment.
Yes.
There also we are reading the same. It is in 2013 minus the amount was under dispute till this period also. That's why the my accounting shows that it was kept shown as being payable in the balance sheet till that date. It says this application filed by the applicant seeks waiver and the stay against the adjust dues, which includes an amount of 69 lakhs demanded for service tax application cess for this period. After reviewing the reports and hearing both sides, we find that a part of the state demand, 38 lakh, is on the ground that the applicant collected this amount of service from service recipients but did not pay the exchequer. From the submissions of the government consultant for the applicant, it appears that the case of the applicant is that their tax liability is only to the extent of 15 lakh rupees, and that an amount of 20 lakh was remitted to the main contractor for evidence to the government. The learned consultant has further submitted that they are not in a position to prove that said amount was remitted by the main contractor to the exchequer. It is submitted that the applicant can only prove that said amount was remitted to the main contractor. And observing this, a pre-deposit of 15 lakh rupees along with interest was ordered on me, which was made by me. And Chan is on page number 155. That is an actual time.
Is the date of
Chan it was
search?
search is in September 2010, 27th September 2010.
After the assessment year of 9 and 10.
Yes, of course.
How can you say that it is yet to be paid?
But on that date, it was yet to be remitted.
The assessment year is over.
While it was appearing as payable in the financials and the invoicing and revenue register was showing this gap, and that was also coming as accounted in the books of account values. The company had some financial difficulties at that point of time, and that's why it must be yet to be paid. But it was not retained by me, my lords. The position of law,
Instead, it is reviewed.
but it was being shown as payable, my lords. It was there was no intention to retain it. Part of the amounts was already remitted to the
Admittedly, you have retained it. And you have retained it beyond the assessment year. And which could be detected only in the course of a search.
Whether the search came to the belief that I am the person liable to pay the tax, whereas the position of law is not that I am liable to pay the tax.
You have collected, you have to remit.
Yes,
That
I have to remit it.
your collects has to remit. Is it not?
I have to remit to the principals and that I am issuing letters.
Your understanding. As per the statute,
My note similar case was also discussed in the case of Make My Trip. I would just like to bring your attention to the judgments of that court. If my notes permit, I can submit the judgment. In the case of Make My Trip, also my notes said there is a 7-member bench judgment of Honorable Supreme Court in the case of R.S. Joshi, wherein it has been discussed that collective doesn't mean mere collection, it means collection and retention. If it is being paid to the persons to whom it belongs, then subsection is not applicable. That
So
is
they have not prosecuted you for that 20 lakh that you have said to have paid. Your dispute is only in respect of the 15 lakh rupees that you retained.
no 50 lakh. I have admitted that I am paying, but they have asked me entire amount of 38 lakh in my notes.
Because you have not shown evidence of payment of 20 lakh.
My notes, the remittance register which I have just shown as in action number 4. Sorry, 5. These are the references wherein the check number details are also given. Every remittance they have verified.
What do you say on that?
Clearly, it is mentioned in the order.
If suppose if they have collected and they have paid it back to the principal, and there are documents to show that their payments have been made to the tune of 20, without there being a counter check from the principal whether they have received it or not, and in turn the principal has paid it to the department or not.
That is even that has been covered in the order.
Where is that? It doesn't say so.
There's not before that, even in the petitioner saying that he was holding another, his reply itself, he also undertakes at page 123, and I just read out not without taking your lordship there. That the service tax amount collected but not remitted shall be paid in installments. This is page 123. In his reply, he says it again here, but doesn't make the payment. Now I take your lordship to the impugn order. And the learned AR submits. I was just reading that same portion. Learned AR submits that if the applicant was not rendering any service to their client, they should not have collected the service tax in the first place. It was submission. Further, they have not provided any evidence before the adjudicating authority to the effect that they have remitted the entire amount of service tax collected by them to the principal. This also gets clarified by the fact that 15.75 lakhs was not remitted and it being shown as payable to the principal in their books of account even after 4 years from the date of show cause notice. This further states, he further states that even from the claim that they have remitted this amount to the principal, there is no evidence forthcoming that the principal has paid the service tax to the revenue. Therefore, in terms of section 74A, 2 and 3, the adjudicating authority was correct in confirming the demand along with interest and demand.
No, he's referring to that page number,
Annexure 5.
annexure 5, starting from page 86, in respect of remittances made. Along with the check number and the date of payment.
Stage 3,
No.
this court going in.
No, if suppose if this has been done,
Because what
that was precise.
the order says is that no evidence. Now,
No.
these annexures over here before this court, he is saying that
He is saying that it has been paid by check, and if it has been paid by check, it's very easy to verify. And these checks, look at the dates of these checks. All of these are 2006, 7, 8, 9, during the relevant period you are saying. So if these,
question asked myself is what prevented him from establishing all of this before the.
that's a different thing.
Why don't we
He says that this is part of the reply to the show cause notice,
Yes, ma'am.
isn't it?
That should be evident from the
No,
show cause notice.
let me clarify. My notes may find that focus notice itself, page 46.
No, was these document annexure 5 part of your reply to the show cause notice?
This is the part, this has been relied upon by issuing the show cause notice.
This very document.
Yes, my notes, and it has been part of my appeal paper also, and it has been part of this news. My notes may kindly have page number 46, paragraph number 18 of the show cause notice. Reliance for issue of this notice is based on the following: balance sheets and invoices and registers belonging to Abhishek Transport. These registers were taken away by the search team at the time of search, and they calculated entire case amounts from those registers.
This is a register, then we have to see multiple balance sheets, accounts, and this is a bank account statement according to me.
My notes may kindly appreciate that this is a settled position of law that in case of 73A, penalty is not at all applicable under 78. However, the respondents have asked me to take penalty also. And it is also a settled position of law that once the order in original is not stating that the reasons cannot be supplied by the tribunal in the appellate proceedings. There are two further points which I would humbly bring my notes to take note of.
So please not insofar as this, whether it was filed and whether it establishes that he has actually paid the amount to the principal, the service tax component. And then why, even in such a scenario, the appellate authority, the tribunal did not look into it, will I'll get instructions on that.
Then the amount get reduced to only 15 lakhs instead of 38.
Yes, Mr.
And also whether these were filed, whether.
But what if these documents were not part of your reply to the show cause? Or even before that?
I am saying these were taken away by the search team at the time of search. There is a wajahat which is not a part of this appeal paper, but it is on the report. In my work permit, I can supply a copy within half an hour, a copy of the wajahat, wherein these registers were taken away by the department. They calculated their right upon these registers, and it is a part of my assessed appeal also, my notes. This is the exact copy. My notes have looked at the lecture file. There are two page numbers which are appearing. First page number is of the sister appeal, which we have cut, and now the page number coming is of this appeal.
On that aspect, I'll get instructions. We will go through this reply.
When?
Next day. Thursday.
The request of the council or the department to us. 20th.
Yes.
20th. That is the request of the council for the department.
We kindly give any date after 21st. Actually, on 21st, I have to go run and I go to.
23rd.
Alright.
Enabling the council for the department to verify whether the document enclosed herewith as annexure 5, annexure 5, showing details of the remittance of service tax to the principal during the relevant period 2006-7 to 2009-10 was available. Two is whether you have got it verified or not.
Yes.
If you have got it verified and you found that these are not proper or correct, whatever it is, that's a different thing.
Government even have to establish it was found that he is not discharged from that. Anyway,
You
I'll
have-
get back to get instructions.
In the course of search, you have collected documents showing details of the check. It is not cash transaction. Check. And the period spreading over for all the 3 years. It's easy for you to have got it verified.
To verify with the principal that he is discharged his tax liability.
That's a different thing.
If he is not, then he is only liable.
Correct. But then have you got it verified?
Whether the principal has discharged his tax.
No, whether the check has been in fact paid or not. And it was cleared or not.
But again, it's
There may be only-
to the principal now. It's not to the department.
True. If suppose if he has made a payment to the principal and the principal also has made a payment, then is he supposed to be? If he has made the payment to the principal has not given it to further to the department, then again he would be liable.
But then he has access to the principal because he is working with it. When he was before the adjudicating authority, he ought to have shown the
Or department does not, I mean, it's not so.
and get instructions.
My notes may kindly give some protective.
What protection? In the 2 weeks, nothing is going to
Till
happen.
next date of there is no action being taken by us.
Nothing is going to happen in between. The order original was passed in April.
And that too is non-speaking my notes.
That's a different thing.
Strictly non-speaking.
23rd, we'll consider on 23rd.
Right. It's right.
Payment of bill. What do we do? The criminal case against the driver of the offending vehicle. How do you establish the accident?
It's
To
true.
be on the negligence.
Still ample evidence is on the record, but that was not.
Accident is not disputed. The question is, did it occur with the rash and negligence of the DD? How do you establish it?
There's two whole evidence there that was not upset by the court.
BW2's evidence, will it not be contrary to the finding of the criminal court itself?
That's true. The final report filed against the deceased. Final report, the court below said wrongly that final report filed against the tipper. That's not correct. Paragraph number 9 it is mentioned. Paragraph 9 mentioned.
See, the driver of the offending vehicle or that tipper must have also been prosecuted.
Not prosecuted. FIR should against the tipper driver. Even the expected to this could also say so, same thing. But at the time of some time, they filed a final report saying that the deceased two-wheeler driver
Was negligent.
and action admitted against him.
And the matter was closed. The FIR was closed.
Yes. Final report filed. Since action abated. Two-wheeler driver died. In paragraph number 9, it is mentioned.
The appeal is admitted for hearing. That notice be issued to the respondents on payment.
Covered by Alon station. WK number 30153.
30.
30th October 2020.
That has both 37 and 38 in it.
Yes.
Loud. What is number 30152?
But to title the into
But 16 to 20 will also additional norms are raised.
16, 17,
19 and 20. 19 and 20.
18 also,
16 to 20.
16 to 20 all.
All 5 members. Yes.
You are also.
That raised additional.
Count. Same order. It will be the same order 30153.
Yes.
9509.
Which one?
They filed amendment petition.
Is it listed?
Posted the order.
Should 3015 should cover it. It's not that anywhere on the card.
90
9508.
1508. There the amendment was allowed and it was disposed of.
Yes, sir.
This is the subsequent order where we have said that the apprehension of either of the parties, whether their right stands reserved for the other objection is concerned, that has also been protected.
Yes, sir.
Police got for raising additional doubt, saying that, I mean, the case was,
It's not an amendment.
But it's not an amendment.
It's only an additional affidavit that when 19 and 20, you are there for the petition.
and for the,
The other three, you are the petition.
I didn't know you were stating it.
Right. Yes.
So 4, this is also.
It's been tried. They want to ask the third respondent money provisionally attached to the.
Who's for the department? What do you say? He says that no show cause notice at all.
Proceedings prior to issuance of show cause notice, 183 itself will say that. And he has a remedy under rule 159.
No, he says even before issuance of form DRC 1A,
Yes,
there was a requirement of issuance of show cause notice under section 73 and 74.
yes, but that is after investigation is completed, then show cause notice will be issued. 83 will not require no show cause notice to be issued prior to action. These are provision attachments, not recovery proceedings.
The two proceedings challenge on the ground, there are no broad reasons recorded, but subject to satisfaction notice to be recorded. But section 83 was interested by various high court, including Honorable Supreme Court in Radha Krishna Industries case. I can see not section 83.
Yes.
Section 83, original attachment. Thereafter the initiation of any proceeding in the chapter 14, chapter 15, opinion that the purpose of protection is necessary to be made by order in writing. Including that, grant to the taxable person or any person specified in of section 122 in such manner as said. But rule 159 is relevant to. 59.
Yes.
Total requirement of the property, where the commission decided to attach the property including bank account. And in accordance with the provisions of the each shall pass in order in TSHC to the effect mentioning therein the details of property which is attached. But the section 2 below, the commission shall set a copy of the order of attachment to the concerned revenue authority, transport authority to place complaints with section over property shall be moved only in the issue to the debtor. A copy of such orders shall also be sent to the person whose property is being attached under section 83. But this is brought not by way of amendment by circular, but in rule 59. Not I filed the circular copy of the amendment also. Not though rule strike not the copy to be marked to the assessing who is affecting, whose property is attached. That till date he has not given any more attachment to me. But I obtained this copy from the banker not with great vigor. Banker was also not inclined to issue because he has no instruction from the department to survey copy. After date persuasion, I could able to get the copy. Then one time we see lot the instructions issued by the department. And how to put the these are the circular instructions issued by the central board. And come to page 2. At 3.1. Particularly, the above provision of the law suggests that the following law must exist according to the provisional attachment of the property under the provisions of section 83 of the Act. There must be pendency of the proceeding as a taxable person under the sections mentioned in section 83 of the Act. The commissioner must have formed the opinion that provisional attachment of the property belongs to the taxable person is necessary for the purpose of protecting the interest of the government revenue. For forming an opinion at section 83, it is important that the commissioner must exercise due diligence and duly consider as well as carefully examine all the facts of the case, including the nature of offense, amount of revenue involved, establishing the nature of business and the extent of investment in capital assets and resources. Reasons to believe that the taxable person is assumed the proceedings referred in section 83 are pending may dispose of or remove the property if not attached provisionally. The basis on which the commission has formed such opinion should be duly recorded on file. It is reiterated that the power of provisional attachment must be exercised in a routine mechanical manner, and careful examination of all the facts of the case is important to determine whether the cases is fit for the exercise power under section 83. The corrective evidence based on the proceeding inquiry conducted in the case must indicate that the prima facie case has been made out taken the taxpayer before going ahead with any provisional attachment. The remedy of the attachment being by its very nature extraordinary has to be resorted to with utmost circumspect and the maximum care and caution. Procedure for provisional attachment of property. In case commission forms an opinion to attach the property, including bank account of the taxable person in terms of section 83, should duly record and file the basis on which is formed such an opinion. He should thereafter pass an order in Form 22 with proper document identification number mentioning the details of the property being attached. Then the 3.2.3, a copy of such document shall be provided to the said taxable person as early as possible, so that objections, if any, to this the said attachments can be made by the taxable person within the time prescribed under section 159.
This has not been done.
They are not given a copy even till now. No reasons are got. See the include what case said. This was home court with Supreme Court and was brought to majority high courts, all high courts. Wherever such cases are found, page number 23. Page 23 note. It is to inform that Mr. Other trading and principal place of business at so and so, where the GST registration number so and so, with the registered taxable person under GST Act 2017, proceedings have been launched against the aforesaid taxable person under section 70 of the said act. Information available with the department is, it has come to my knowledge that said person has a current account in your bank having account number also. In order to protect the interest of the revenue and in excess of the power conferred under 83, I so and so, municipal commission, hereby provisionally transfer the aforesaid account. That's all. No reasons are, no kind of seamlessly agreements for various courts, not including the Honorable Supreme Court. Page number, page 23. Our final conclusions may be the order of provisional attachment. The order of provisional attachment before the assessment order is made may be considered with the assessing authority or any other authority in court in law is of the opinion that it is necessary to protect the interest of the revenue.
Just once again, where are you reading it?
Page 23, 51, 52.
Yes, yes.
They said our final conclusions may be, and then wrote the order of provisional attachment for assessment order is made, may be executed in assessing authority or any other authority empowered in law is of opinion that it is necessary to protect the interest of the revenue. However, the subject to satisfaction should be based on some legible materials, information, and also should be supported with supervising factor. It's not any every material, however vague under the state promoter part which would warrant the formation of the bill. The power conferred on the authority under section 83 of the act, for the provisional attachment should be termed as a very drastic and far-reaching power. Such power should be used this sparingly and only on the subject to weighing grounds of reasons. The power of provisional attachment under section 83 of the act should be exercised by the authority only if there is a reasonable apprehension that the SHC may default the ultimate collection of the demand that is likely to be raised on completion of the assessment. It should therefore be exercised with extreme care and caution. The power under section 83 of the act for provisional attachment should be exercised only if there is sufficient material on record to justify the satisfaction that the SHC is about to dispose of. Only any part of this property with a view to provide the ultimate collection of their demand and is on in order to achieve the said objective, the attachment should be of the properties and to that extent it is required to achieve this objective. The power under section 83 of the act should neither be used as a tool to harass the SHC nor should be used in manner which may have an irreversible detrimental effect on the business of the SHC. The attachment of the bank account under trading assets should be resorted to only at a last resort as a measure. The provisional attachment under section 83 of the act should not be equated with the attachment in the course of the recovery proceedings. The authority for exercising power under section 83 of the act, provisional attachment should take into consideration two things: whether it is a revenue neutral situation, the statement of output liability or input rate having regard to the amount paid by reversing the input tax rate. If the interest of the revenue is sufficiently secured, then the authority may not be justified in invoking its power under section 83 of the act for the purpose of provisional attachment. Then not the referred to the judgment in the case. Kindly come to next paragraph. 20 last page 25 extracted.
Yes.
Last in the middle of that page, not water. by relying on the government method. After there are 20 minutes,
Yes.
by relying upon the government made in the opposite paragraph, an attempt is made on the part of the land and assessing government appealing to the respondent to submit that there was sufficient material with the assistant commissioner to arrive at the subject to satisfaction necessary to pass not a provision at to protect the interest of the revenue. We are not in a position to accept such submission. What has been stated in paragraph 17 to 20 of the 15 reply has something to do with the merits of the case for which notice under section 73 of the CGST Act 2017 has been issued upon the writ application and the proceedings are pending before the consent authority. What is lacking in the present case is credible material needs true sense for the purpose of arriving at the subject to satisfaction that the order of provisional letter is necessary for the purpose of protecting the interest of the revenue. In the case of Warriors Industries, we have taken into the commission are not able to delegate its power of provisional attachment created the act the assistant commission. Therefore, in the case on hand, the order of provisional attachment as well as the order of probating are not sustainable on two counts. The order has been passed by the assistant commission and the order has been passed without any credible material available for the purpose of us. Then note in the result application section, the order of provisional attachment by the assistant commissioner so far as removal property is concerned is hereby passed and set aside in the same manner. The order of provisional attachment to the bank account is also hereby passed and set aside. Then
Yes. Just let us hear the other side. What do you say?
Yes, I could, in fact, there are some that think also make your argument out of this very code, which has always maintained that there is rule 159(5) against the provisional attachment. When the petitioner has, or the act provides for him filing his objections before the authority who is attached to the bank account.
These, what do you say about these guidelines that were framed by your department?
You can see on the same guideline. At 3.3.1.
Yes.
I'm just by going through the writ petition, or if the petitioner's case falls under B of that pattern. 3.3.1 may I read out?
Yes.
As mentioned above, remedy of attachment being by its very nature extraordinary needs to be resorted to with utmost circumspection and with maximum care and caution. It normally should not be invoked in cases of technical nature and should be resorted to mainly in cases where there is an evasion of tax or where wrongful input tax credit is ever utilized or wrongfully passed on. While specific facts of the case need to be examined in detail before forming an opinion in the matter. The following are some type of cases where provisional attachment can be considered to be resorted to subject to the specific facts of the case. Where the taxable person has supplied any goods or services or both without issue of invoice.
No, these are the cases where the provisional attachment. He is not saying that it cannot be done. It can be done, but after undergoing a process of law, or whatever the guidelines has been laid down for that.
These really fall under B, so that this case will fall under B.
Yes.
Issued any invoice or bill without supply of goods or services or both in violation of the provisions of Act or rules made thereunder.
For which you have already initiated proceedings against him.
Proceedings of search, etc., may have been initiated, but attachment of now he will utilize the input tax credit, or he will not end up paying. So this opinion on these are cases where by going through these are scrap figures. And in steel scrap figures, where this entire investigation over 200 companies have been undertaken, where there is no supply of goods, there is only invoices, and that I explained the other day as well. This appears to be one of such people. So in these cases, therefore, the opinion, Constituency 83, does not say reasons to be recorded in writing. This forms an opinion order to be passed.
What is that? What is that?
Then I have to get instructions.
What is that? Even if there is an opinion form, if it is not reflected in the impugned order also, then where is that formation of that opinion?
I have to see what summons been issued, has statements been taken of this,
If we prima facie go by the contents of Annexure P1,
yes, sir.
it appears that contrary to the guidelines, where they say that it should not be resorted to as a matter of routine. It appears here that it has been resorted to as a matter of routine. Since there is a prosecution initiated against them, therefore, in terms of section 83, it becomes necessary and they have passed an order of provisional. If you read paragraph 1 and paragraph 2, this is what prima facie reflects.
Yes. Secondly, not it is sectional line and that where it appears notice has been issued.
Let us keep aside the judgment as of now. We
Yes.
are only following the guidelines that have been framed by you, your department.
Yes.
They have specifically pinned down. These are the circumstances which have to be ensured.
Not the opinion has to be there, not the guidelines prescribed for it. Whether it has to be reflected in the order of attachment is the second question.
Correct.
That is not, if you Lordship see the guidelines as a section, it says, show that it needs to be reflected in this order. The requirement is that the opinion needs to be formed. Right?
Where, how?
Then I have to get instruction, because whether or not special question is coming up today for the first time. The opinion formed, in fact, I can say with some certainty there will be material on record to show that the commissioner has formed an opinion based on certain material. It cannot be that without any material on record that this is being attached.
Tomorrow,
Day after tomorrow. Yeah.
Hyderabad only.
Sir.
This is from Hyderabad only. You can get it by tomorrow.
Day after tomorrow. Monday and Wednesday.
Day after tomorrow, right? Day after tomorrow at the request of the council for the department.
Does the attachment order was served on the CC or not also? Have you verified?
And if one submission will show part of that, and also find out this being served. The non-service may not be, I'm saying some portion and all major logic may not take it well, but the non-service will not take even principles of national justice, etc. And logic to also see what are the consequences there. So it is not
Objections, he can file.
he can file now because he has it, his rights as it then.
But he's saying the Honorable High Court of Andhra Pradesh, where I tried a copy, but found fault with the department, but arguing the same issue. They said they don't do the copy, they don't mention any reason, but they are expect me to file the objection. What?
When would they file the objection? When you give them an order.
You have to show that not the order.
May 23, we are in November 23. 4 months have passed.
But I'm also informed of this DIN number which is there. 59 document page and DIN numbers. This information is a very number. Also, that information to my knowledge would have been transferred to the SSC. And this DIN number, on this DIN number, he will get all of these online. He can always look at whatever the orders have been passed, what has been done, because these document identification numbers have come out for that reason.
No, is it your procedure where you don't send copy of a provisional
I'm not saying
attachment?
that.
Then if you send it to XYZ, why not to the ABC as well?
That's not the after tomorrow, I'll get instructions on that.
Yeah.
Challenge this appeal is whether it's the rule 8 of central executive. There is page number 15 is the CSAT order. Similar circumstances export relying on various high court judgments for that Punjab and Haryana report include this Telangana report. They like us to invert this. The government has passed an order. Others in this case where the other high courts has declared that 8 years unconstitutional. Here it's a case where never that's a delayed payment method. After that method, it's they have submitted a calculation amount where it's a lot of status. It's locations. Applicants of the manufacturers of general purpose machines and are registered with central excise department. They were availing the prescriptive SENVAT credit of duty paid inputs services for SENVAT credit tools. During scrutiny of the returns filed by the SSC for the month of January 2011, it was noticed that though they are liable to pay duty amount of 77 lakhs 33,662, the SSC paid only 58 lakhs 43,334 by debiting from SENVAT and rupees 18 lakh 60,000 from the personal ledger account. Therefore, there was a short payment of 23,000, 25,300 on the part of the SSC. The department was of the view that having failed to make the payment, it was violent for subsection 83A of Section 2002. Then when show cause notice was issued to them, published demand. Duty that has been paid short paid and the duty which has been paid using the semi credit analysis department. Then when they have filed a calculation memo saying that they have paid an excess amount that you must be finding page number 17. The appellant had paid 68,008 as excess duty. And there was a short payment towards the education system higher education system to an amount of 21,469. 3,850 respectively. I'm coming to know about the short payment of the cess and higher education system as well as the excess payment of the excise duty. The payment to the department by later dated so at this excess excise duty towards the short payment. The department did not give the records necessary as initiated the procedure. So, page number 63, paragraph 6 for X. On pages of the page number 38. The applicant here is the Commission of Central Excise, Central Excise and Service Tax. Respectively, responding here is
Where?
page number 38. This for the application because now the assessing final memo calculation was saying that they have paid an excess amount. But department is disputing that calculation memo. That's you are still finding operating question at 3.1. Page number 39. In the calculation sheet submitted by the Land Council, personal ledger account paid was shown 18,42,682 excise duty, whereas scrutiny of PR1 letter filed the month of January 2011 revealed that an amount of this 42,682 paid by challenge number dated was at least for other payments to be made on account of the audit practice as mentioned at page number 4 of the year, and this has been clearly mentioned under serial number 4. The details of the duty paid on accessible goods contract on account of current cash payment. Ledger 3 has the opposite amount of 18,42,682, includes an amount of rupees 42,682 paid for the audit balance. Therefore, an amount of rupees 42,682 stated to be an excess paid and the excess duty by the Land Council appears to be not correct. Then we have another. The Land Council is showing service tax input utilization of 8 lakhs, whereas scrutiny we have to reveal that only an amount of 7,74,671 utilized from the service tax account. Therefore, an amount of this 25,326 different between so to state to be excess paid under the excess duty by the Land Council. Paragraph 2. The applicant filed an application on 63/2020 for rectification of the mistake under subsection 2 of section 35 of CSS. In view of the applicant letter apparent applicant and the claim to pass to the orders, the applicant applies the withdrawal of the application by verification of the mistake as the applicant is filing the appeal. Because since we are filing the appeal on the record of Telangana, the substance question lies in one. None of the substance question lies in one. Rule 838, it's a channel for example. It's a rule 838, it's a that's a goods lifted ballot account section 8.1 they are supposed to pay 6th of the succeeding month. If it is paid by way of electronic element, it is paid on the 5th of the month. Since we are disputing the ballot amounts paid ballot, it's the calculation everything.
But if rule 8.3A has already been declared otherwise.
I'm bringing your service knowing there are 4 high courts including this court ballot and I can speak saying that rule 8 is untouched. But here is the case where there is a substance clearance there. It's therefore submission the maximum demand back to
Calculation error, we will permit you to revise your application for rectification which you have moved. Which you moved and you withdrawn yourself in the light of the appeal that you had filed in between.
Yes, ma'am. That's the reason we have withdrawn only the light of the appeal. Now, it's now second. We are disputing that they can.
So we will reserve your right to reviving your application for rectification. Because that would be a factual aspect.
Yes.
That we cannot look into at this stage.
It's my request is on put.
This present appeal has been filed only emphasizing on 838.
838.
838, this court has also many other high courts have taken a view. So that part we will keep it open.
Subsection, Your Lordship, the calculation errors which are within the Your Lordship, even for the show cause notice, they should get requested and to adjust it, Your Lordship. However, since the department was not permitted to adjust, Your Lordship, subsequently in the month of July, they have made the payment, Your Lordship. So even if the master is remanded back and they file the rectification.
No, there's no question of remand. We don't intend to entertain the appeal also in the light of the view that we have already taken. What we say is that they had already moved an application for rectification there. They had themselves withdrawn it in the light of the appeal pending over here. So if at all, if the department wants, they may pursue that remedy again. That's all.
There is no short payment also.
No, if at all. If at all. Present appeal is one which has been filed by the department appealing the order passed by the
Keep high of 2020.
Give us item number 7 first. 6 to 10 are identical.
Identical, related to the same order.
Different assessment, yes.
Different assessment.
Yes.
It's the affiliate was the partnership firm engaged in the business of recruiting manpower to software companies in US Europe. It processes their H1B visa students and then send their business abroad. Europe, during the course of the business Europe, it collects certain refundable security deposits of the visas so that they don't run away after they have got their visa and join some other company instead of joining the company with which they stay. This deposit is refunded the minute they get their visa and join the company in US. This amount is now sought to be taxed by the revenue as the income of the SC. That is the whole dispute. In fact, this has started owing to such proceedings in one of the sister concerns of the SSC, against which appeals are pending before my lords ITT 69 of 2021 in batch.
So those are admitted.
Those are admitted.
Same ground.
No, grounds might be different, but arising out of the same search. Once they search in that,
What is the challenge in that?
there are various editions, but it's not this edition is not there in that.
So therefore, a decision on that appeal would not be
May not
of
be
any consequence to
totally
the.
relevant, but if the search is held to be bad in that, maybe entire proceedings have to go. Editions are totally different.
What is it?
Editions are not nowhere related because companies are different. Their objects are different. The way they operate are different. Because the only issue before my lords is page 5 lords. Substantial questions are there. Paragraph 10.
What is the duration during which you retain this security deposit?
Till they get their visa.
No, till in what sense?
It depends. Maybe some cases it may go on because we give them coaching for certain examinations.
So it is there with you for a couple of years at times.
May not. In some cases it is only for visa. It varies from case to case.
That's what I said. In some case, it could be a couple of years and it could be even more.
Yes. But nevertheless, all those money are refunded. There is no denial of the fact that those monies are withheld by the SSC.
As long as it is with you.
I might be, if the department is taxing me on the interest I have earned on those monies, by chance, if they have made them fixed deposits, to that extent I am liable. That is not the issue here. The quantum asset, it has been refunded back to them. Because if that is the case, they should also grant me the benefit of treating that amount as expenditure. Then, if they want tax it as my income, the minute I give it back to them, they have to allow it as an expenditure. They can't cut the cake and have it too. It has no character of income.
Only A is sufficient.
A and B because there are confirmation letters also.
That would include in
And
the appeal is admitted for hearing on the following substance. Page 5, A. Who will take notice?
JV present and police appearing.
Will mark your presence under his instructions. Ms. Manasa under instructions which J.V. Prasad enters appearance and
Item 6.
You have mentioned all the items over here. Take out the copy of this order sheet, fix it in all the appeals. It is not there. Look at this copy doc. Where is the order sheet at 11:10? Okay. In fact, your name has been. It was ordered like that only. That instead of Sri J.V. Prasad name, reflect the name of Ms. K. Mamta for the income tax.
We have a fine that verify. Take fine.
On the 5 appeals, the same question. That's
No, there is a specific order. The registry is directed to reflect the name of Ms. Mamta in place of Sri J.V. Prasad. So that we are not touching with that. Which one's on? Since you see the appearance on behalf of the object and respond. Let the appeal be listed for hearing in executive reports. 6 to 10. Same. Yes. The same ground in all.
actually on
The same question of law is covered in the lordship. Four other LTAs.
ITTA.
LTTA 191, 192, 228.
191.
Yes. 192, 228. Oh, 222. 191 and 192 were admitted. 228 on 27 July, 230 on 26 July.
The question of law is same.
Lordship may take 1 and 3.
In the other one,
2 is in fact combination of factual issue.
the following appeal is admitted. The appeal instant appeal is admitted for hearing. And the following substantial question of law. Page number 4, 1 and 3.
The other appeal also was not great. 1 and 3 was.
It has been informed that there are other connected appeals of similar nature which have already been admitted. Fourteen not connected.
Well, the 13th file has been missed. The lordship may take up.
13 at the request of the council for the appellant is this case on the 5th of December.
our name is not mentioned in the
Which case?
30.
13 for the respondent.
Yes, you are.
Let the name of the so and so be mentored mention with the cause list from the next date of hearing for the respondent. Yes.
Petition.
14 is done to file. Around another 3 weeks, second order of issue.
14 Ms. Mamta appearing for the department waits for time to file counter has paid for time granted. Is this case on the 6th of February, the interim relief earlier granted to continue? 6th of February, yes.
Your Lordship. I already filed a counter, Your Lordship, exception counter.
Not yet filed.
Counter filed, Your Lordship.
Number 5,
What else?
no rejoinder required,
Uh,
not required.
It's a legal issue, but the notice, have challenged the notice period, where the notice was not signed physically or digitally. It's a jurisdictional notice, my lord, issued under section 148.
Mr. Radhakrishnan, are you ready for the hearing today itself?
Yes, your lord.
You are ready? Yes.
What should we kindly see the issue number? Notice at page 30,
Page
1 3. This is the notice issued for but get a T copy for reopening the assessment. But still notice that it is not signed. Neither physical nor by way of a digital signature. In fact, under the name of the officer, it says that in case of digitally, the document is digitally signed, please refer to digital signature at the bottom of the page. So it is not signed. And in fact, they filed counter. They never said that what is placed is an incorrect copy or rather copy. They say, but they don't deal with the requirement of that. Section 96, section 282A. That requires one of the taxes or digitally signed. Two 82 capital.
two 82.
Capital.
In that page.
I'm looking at the T1.
You got it. You got it. Authentication.
Application of notices and other documents. Subsection 1. Where this act requires a notice or other document to be issued by any income tax authority, such notice or other document shall be signed and issued in the paper form or communicated in electronic form by the authority in accordance with the procedure as specified. What it is, in fact, if I can read subsection 2 also.
Subsection?
2 also.
Yes.
It deals with the authenticated form.
Every notice.
Every notice of document to be issued serve as given for the purpose of this act by any authority, by income tax authority, shall be deemed to be authenticated if the name and officer of a designated income tax authority is printed and or otherwise written. These are the two sections. Deals with the first one requires my lord the signing, that is the essential part of it. The second is the authenticated form. Now, the first requirement, my lord, of signing the notice is totally absent in the proceedings. The authenticated copy will come only if it is a copy which is placed in the income tax.
In addition to the signature, the name and the office of the designated authority is also required to be printed. Under subsection 2.
Even yes, well, physical form they mention. But even in the digital signature, when they sign, the authority who is signing, in fact, that is I can find out from
The authority's designation must be reflected there.
the person who is signing the authority. If you also kindly see page 16, in one of the notices issued subsequently,
Page?
page 1600. In fact, it starts at page 14. There's a notice issued in the course of the years. Page 16 contains the digital signature where is the name of the authority kindly reflected. It's a digital signature.
Yes.
Right at the bottom. So, in the counter, which is filed, but
There is a jurisdictional notice for exemption of jurisdiction to make an assessment or a reassessment. But, because this defect number is not curable. In fact, they don't even plead that number then the form that. In fact, they admit that it is lacking. There are three of the on page 2 of the council. Line about 7. In fact, last line. Well, two things from this counter claim. One is they would dispute the fact that it is not signed either physically or digitally. And they don't even say that it is existing in the record. So my humble submission, because the jurisdiction of reopening is not signed in the manner which is known to law.
What do you say, Mr. Alex?
Your Lordship, the notices are served to the petitioner, Your Lordship, and also my clients, the petitioner is contention that the digital signature signed by the competent authority, Your Lordship, is not correct. What is my land fund is questioning that, Your Lordship. They kindly see that, Your Lordship, page number 6, page number 7, Your Lordship.
7 of
7 of my counter, Your Lordship. The notice issued under section 148 of notice is the digital signature of the competent authority, or digitally signed by the ITO board is a competent authority. And the 151 notice was issued with the approval of the first response competent commissioner, Your Lordship. That is the commissioner is an PCIT to Hyderabad, Your Lordship. The 151 notice was issued. And he has not submitted anything, Your Lordship. The digital signature is everything the competent authority only. Without approval of the notice, they can't give any notice. You need to,
where is the digital signature?
Yes, Your Lordship. Digital signature is also stated, Your Lordship, under page number 8, Your Lordship, 151 notice at the bottom, Your Lordship. Yeah, and also and ending, Your Lordship, page number 9 and last, Your Lordship, in the document is digitally signed, phone refer to the digital signature of the bottom of the page. That is there, Your Lordship, bottom. Last 9 paragraph 9, page 9, last, Your Lordship. Digital signature is there, Your Lordship. Bottom. Last, Your Lordship, the bottom below, Your Lordship.
This is under 151.
This is what was required in the notice.
Without approval of the competent authority, the authority won't give any notices, Your Lordship.
Where is this sign of the authority was issued this notice under 148?
148 notice, Your Lordship, the competent authority, ITO, Your Lordship, concerned ITO.
Isn't his signature is not required?
Digital signature is there, Your Lordship. This signature, digital signature, online signature, Your Lordship. This was there.
Where is that?
Yeah, page number 7, Your Lordship.
Page number 7, there is no such endorsement.
In case of the documents digitally signed and they refer to the digital signature at the bottom of the page next, Your Lordship, continuation there. Continuation is there, Your Lordship. That was now.
Where is the continuation?
Continuation. See the hand, Your Lordship, I find in the document, Your Lordship, the signature is there, Your Lordship.
See, page number 7 of your counter is the notice under section 148.
Yes, Your Lordship.
Page number 8 is an approval under 151.
Yes, Your Lordship.
151 has a digital signature.
Last signature, digital signature is there, Your Lordship. Here. And that also the original file also the digital signature is there, Your Lordship. Without putting any signature, Your Lordship, competent authority won't give any permission to anybody, Your Lordship.
Where is that in this impugned order which you have served upon the petitioner?
Yes, Your Lordship, that was there, Your Lordship. That digitally, which is an address is given to the PAN number, the address, Your Lordship, is sent to the mail address also. That one.
So therefore, signatures are not required.
Now, in this already this not required. See, because after issuance of this your lordship, CBC circular your lordship, the digital signature is a consent only your lordship. Uploading it.
Where is
And the note file after approval of the note file your lordship, they uploaded to the digital signatures only your lordship. The other person cannot open that your lordship without having a digital signature to competent authority. I stated so in my counter also your lordship.
Where is that? What have you stated in your counter?
Your lordship, the page 2 your lordship. Page 2. In para 2, in reply to para 2, so it is respect submitted the totally incorrect so and so, the illegal and also issued without following as verified when the SSC's PAN and address, the PAN was as well as the territorial jurisdiction vested with the respondent number. Who is the respondent number 1? I2 ward 81 your lordship is the respondent number in time. And the second para 3 your lordship, the issued the ITBA portal income tax department through the authorized user ID respond number 1 was the properly marked with the DIN number document number so and so. The notification notice was all duly served to the SSC. The SSC as well as aware of the issuance of the notice and the necessary compliance to be made in response to the same. Hence, the SSC ascertained that the notice is honest merely because digital signature lacking is not incorrect and hereby that is the reality.
Where is the compliance of section 282A?
Yes, sir. The proper channel only this was complied your lordship taken into consideration, consider the request of petitioner your lordship.
Council, there is a requirement for compliance of the provisions of 282 capital A.
Yes, sir.
Where in the impugned order is the compliance reflected?
That file that papers are not there your lordship. That
Neither is it part of your counter.
yeah, part of the counter only your lordship I stated so your lordship. That
Either there had to be a signature or there had to be a digital signature.
digital signature your lordship.
Where is that? Neither this annexure A P1 does not have either of the same.
In the note file, there you love it. And also the code was issued to the competent authority. The other person cannot open that code, your lordship. Only that person only can open. I stated so this also your lordship. The department authorized user ID and respond number 1 was only properly marked on with the DIN in identification number. No other person can do it, your lordship.
So therefore, even if it is not signed, it is immaterial.
Signed signature is there your lordship in this note file and approval of the note file and upload that was uploaded copy without signature they won't upload your lordship.
So council, we are repeatedly asking you where in annexure P1 or in page 7 of your counter do you find either the signature or the digital signature? Where is that?
Signature, digital signature is there, that is your lordship.
Where is that?
Your lordship, it may be next week I'll get it the note file also your lordship. I produced before this honorable court your lordship.
Note file, we want it from the impugned order.
Impugned order your lordship that
P1 page 13 and page 7 of what your counter is the same.
yes sir. Because there is no other person except the opening of the competent authority only putting up this digitally your lordship, it can open your lordship, a DIN number.
So we do not find the digital signature there.
I'll get it your lordship, produce the file consent file before this put your lordship, post up next week it may be any date your lordship.
We want the file, we want the...
I'll satisfy your lordship that.
What?
For the digital signature and everything, I'll produce it your lordship. File, note file is concerned.
No. Digital signature should be there, part of the impugned order itself, notice itself.
Yes, your lordship.
Where is that signature reflected in your annexure P1?
P1 is there that your lordship, under the last the competent authority commissioner approval only this was issued by your lordship, digital signature of this one.
Again, you are repeating the same thing. We want the digital signature to be reflected in that notice. Where is that reflected?
that ground cannot be taken into your lordship, the client, your lordship, the petitioner to avail this remedies, your lordship. Sir.
I,
Because
if there is,
note file itself, that note file itself, your lordship, they clearly stated that there is no other person can the person, the competent authority only can be digitally opened, your lordship, by password, DIN number and ID number.
if the provision of law requires a signature to be there,
Here, signature to be without signature, your lordship, they won't issue, your lordship. There. And
where is
para 2 also clearly stated my para 3, your lordship, my counter.
you say that without signature it cannot be issued, then where is the signature on that notice under 148?
Because applicant request the stay, the was also considered by the lordship. On the ground, your lordship, they can't escape from the showing the particulars to the what which the commissioner is asked for the details on it, your lordship.
Mr. Counsel, what does 282 capital A say?
The escape, the proceedings copy, your lordship, page number 8, your lordship, sir. Page number, my annexer, your lordship, page number 8 and
Page number 8 is the proceeding
The-
under 151.
yes, 151, your lordship.
What about 148?
148, your lordship, that also, your lordship, that note file in the present copy, your lordship, that only signature signed is there, which in a copy is stamped only by filed in the counter, your lordship. In the, my land fund is showing before this court, your lordship, in the counter, that sign is not there, your lordship. Here, I filed a counter language signature, is attested signature is there, your lordship.
Where is that in your counter? Where is there?
Page number 8, page number 7, bottom is certified true copy, your lordship, this one. Same officer is Pratap Singh. Ashish Kumar Nene. Page number 7, last bottom, your lordship, the certified copy issued by the concerned.
True copy. The impugned order does not have a signature. This is a certified true copy by some other officer.
Yes, some other officer is signed, your lordship. The counter filed by the first respondent only, your lordship, stated so clearly, your lordship.
So, and the notice under 148 is without meeting the requirement under section 282.
Yes, your lordship.
So it goes. Petition deserves to be allowed only on that.
That, your lordship, the para 4 also clearly stated that, your lordship, that authorized user ID and portal ID, that only competent authority can open it and can also upload to the respondents, petitioners address, your lordship. Para 4, my counter. To just submitted the 148 notice ID portal of the income tax department through the authorized user ID and respond number 1 as only properly marked within a DIN number. So the notice was duly served on the SSC through the online mode. The SSC was available about the issuance of the notice and the necessary compliance to be made in response to the same. And the SSC said not notice non-honest because this clearly stated so that they deny the contents.
2A. No, 1. No, that is in addition to his signature. See, one says there has to be a signature. The purpose of subsection 2, what we feel is that it should not be as such that there was only a signature by one of the authorities without reflecting who the authority is, what his name is, what his designation is. Therefore, subsection 2 also was inserted that in addition to the signature, there would also be the name and the designation also reflect. But it's not either. In addition to 1, there would also have been requirement of. So that is either a signature or a digital signature. We presume. There cannot be a third procedure other than these two. Correct. In addition to 1. Otherwise, no, it doesn't say so.
There's no
First,
break.
yes, sir. So the first requirement under 282A is that any notice which is issued has to be signed or a countersigned, or the digital signature has to be there. That states. And then this is the first requirement. Second is the name of the officer and the designation of the authority who is issuing it also should be reflected there. So it should not be that even if there is a notice issued with only a signature, without the name and designation, also it becomes contrary to subsection 2.
And we, body needs to be updated.
Correct.
The name and office of the designation of stamp or other people there.
Correct. In that case, then subsection 1 is not required at all. The very purpose of subsection 1 is that it has to be a signature signed, duly signed rather.
But in fact, this is only to authenticate. Like one of the, for example, commissioner appeals or tribunal issues an order. The original order is never circulated. It's an authenticated copy which is issued first. The original will be retained in the file. That is what the intention. But the authority who is passing or issuing notice on the independent.
There is no judicial precedence.
In fact, these issues are arisen before tribunal, but I can't cite that. It's a simple.
But what have they taken?
Yes, a notice without a sign. I mean, it's not a notice. In fact, it's not a notice.
In contravention to the statute of rules.
We make it unsigned document, judgment on unsigned document. But that's intersect.
If we quash this order, reserving the right of the department to proceed in accordance with law. This is only on technicality.
Maybe
So that is not feasible. That way it's not, it's a jurisdiction notice, it's not.
No. We will hold it to be bad in violation of 282 capital A, reserving the right of the department to proceed in, if at all, if they intend to. We cannot close it for all times.
Will rather be understood as language.
No, reserving the right.
Okay.
Yes, Mr. Radhakrishnan.
Pardon me, Your Lordship. Your Lordship, I clearly stated that also, Your Lordship, the same respondent with the competent authority, he filed a counter before this honorable court stating that they already served the notice on the online only.
So therefore, henceforth that officer need not sign any of these documents.
No, connected files, I think so, running files, Your Lordship, they without having any digital signature can't be take further any action, Your Lordship.
Where is that?
That is in the note file, the content, if the webs in the website, open it, everything will be reflect, Your Lordship. Known to the petitioner also that things.
So according to you, the digital signature would be in the note file.
Total file contains for digital signature also there, Your Lordship. And no other person can open it, Your Lordship, that website.
No. According to you, the digital signature will be there in the note sheets.
Yes, Your Lordship.
It is not required in the impute notice.
No, already taken steps on it, Your Lordship. But according to rules only, we have taken new rules, Your Lordship. That.
Then why was the digital signature reflected in the notice under 151? That digital signature also could have been reflected in the notice.
That also that also I mentioned in the year also the competent authority who is filed a counter before this honorable court is a competent authority, is a respondent, Your Lordship. He issued a 148 notice only.
But your counter says that merely because it is not signed, does not lack jurisdiction. You say don't say that it has the digital signature is there in the note sheet.
That, Your Lordship, that.
In paragraph 3 of your counter,
yes,
you don't say that the digital signature is there in your note sheet.
That Your Lordship, and paragraph 4 also clearly stated that, Your Lordship, that the response number 1 is properly marked with the DIN number so and so. The notice was duly served on the ICC through the online mode, Your Lordship. The SSC as well as aware about the issuance of the notice and necessary compliance of the mode response to the same.
So therefore, the signatures are not required. Even if signatures are not there,
Digital signature, then there is no other person can open it, your lordship, issue any order, your lordship. Digitally only can open, is a person using a specific code.
so we are allowing the petition to that extent.
That your lordship, that on the ground, your lordship, merely on the ground, your lordship, facts are concerned, your lordship. The petitioner has not submitted any of the cash, deposited the cash also, arranging the cash, that was not also clarified to this till today, your lordship, that this was issued to this is in a particular year of 2013-14, your lordship.
Why was your officer so much of haste?
And under section 151 also clear that digital signature, everything is there, your lordship, notified there. He received the notices, your lordship. And for the purpose of this only technicality, your lordship is taking objection, your lordship, before this.
Technically, it is the requirement under the statute.
That has complied, your lordship. Requiring the statute, your lordship, the complaint authority only signed, your lordship. Only for this also, the 151 notice also clearly digital signature is there, your lordship, there.
Where is the
All other connected note files also the ASCL are there. Only this one you will also question it. And this was pointed out when taken into consideration, note one, verified after taken into consideration, your lordship, the 2031 identified your lordship department. Came to notice that you have taken all the steps, your lordship. The SSC has not filed any written on 2013-14. It was taken into note, your lordship, the inquiry into the matter, your lordship.
we are allowing it.
Tell me, your lordship, that.
They have struck down.
Before.
Can you just send it? Can you just read it, the operative part?
Expression shall be cited. A1 of the signing of which should not be by that authority mandate. Not a municipal act, or mandate is intention. Sign means to sign one thing. Sign one thing, whether signing for one person against criteria, the fixation is marked as a person. Document must be signed or marked with care. Person signing it or fixing the mark is the author of it. Therefore, or other document as a one of the act. The office signed by that authority.
It has held it to be a mandatory requirement. That is WP.
Tax number 554, 2020.
Can you just give us a copy?
That is this detail.
Before. PNR now.
May. The. The other day.
Can we have it at 2:30?
I will difficulty at 2:30 and not here. Then the various big buyers say that we might be requesting the lawyers to come at 3 o'clock.
The other day, your lordship was the question that the exemption list is not supported by any notification. But a notification is the year 2017.
The compilation and identification is there.
2017 notification.
Yes.
Given a copy to the other side.
Yes. Is 138.
All the counters is like counter of R3, R4. This alone shall suffice, not what we not change.
Yes. But page 1, it starts at page 138.
138.
Yes, but it is dated 28th June 2017.
June 2028. Yes, 27.
But in exercise of the powers conferred by subsection 1 of section 11 of the Central Rules and Services Act, the central government being satisfied that it is necessary in the public interest so to do. On the recommendations of the council, hereby exempts intra-state supplies of goods, the description of which is specified in column number 3 of the schedule appended to this notification. Falling under the tariff item, subheading, heading, or chapter, as the case may be, as specified in the corresponding entry in column number 2 of the said schedule, from the whole of the central excise tax payable thereon under section 9 of the Central Goods Act. So on so. Here the schedule is there, the serial number, chapter, and description of the goods. We are lastly kindly turn to page 139. We have serial number 20, 30. Human hair unworked whether or not waste, washed or sourced to waste of human
Yes.
Therefore, that the exemption given is supported by the notification of the central government. That either the petitioner, not the correspondent, the temple millard are not liable to pay millard the GST millard for this millard commodity. Now, that in the compilation, my letter millard has read on the judgment of the Honorable Supreme Court at millard page 173.
You are also relying upon his compiling.
But I want to blood district is that judgment is not made applicable to blood this present case. Why? Because blood this entire judgment on reading just blood at a glance, blood just on blood the paper because blood supplied. Blood it is blood only applicable to blood the interpretation is required if the language in exemption is blood ambiguity. If the language is clear, then there is no interpretation is required. That is the judgment purpose of the judgment. So therefore, this judgment has no application to the facts of the case. So therefore, I am entitled for exemption.
Yes, Mr.
The other day, when Lordship, learning counsel to the petitioner also did not address first on maintainability. I understand Lordship will go into the merits, but the merits will become academic if your Lordship find out that the writ itself is not maintainable. At least two grounds. First, that the petitioner has participated in the tender process. The tender conditions prescribe for 18% GST on the rights to collect human hair. He did not object to this condition. He participated, he was a successful bidder. After having participated and accepting these terms, he then comes to challenge it. On that ground alone, this writ is liable to be dismissed. There is no escape from that. Secondly, the tax now is leviable on respondent number 3. If anything, it's a contractual dispute between respondent number 3 and the petitioner, which also would question the maintainability of the writ in a contractual dispute on these two. And also directly on, there is a judgment they just came across now in the Supreme Court judgments which have already upheld the proposition that once you have participated in the tender, you cannot challenge the conditions of the tender. 18% GST was a part of the tender conditions for the rights to collect human hair. So one, may I pass on that judgment? The Kerala High Court judgment on directly on the tax issue, I have taken it. Otherwise, the Supreme Court judgments as well. Your Lordship. Possibly normally in other tenders in particular Lordship.
So according to you, I will be more influenced by the Kerala High Court.
This was since it was a tax issue. Like the Lordship may have had the occasion in many of the IOCL matters, this issues come up, where people challenge the tender conditions after having participated.
That law is almost settled.
Yes. Now here, Lordship may see the 4 numbers. I'll read paragraph 5. As I rightly pointed out at the Standing Council, clause 11F of the general conditions of tender specifically stipulated that all rates quoted should be inclusive of sales tax also. After introduction of GST regime, the term sales tax has to be understood as goods and service tax. Thus, the tender document provided for inclusion of goods and service tax. Moreover, payment towards the second and final part were accepted by the petitioner without GST. Any doubt regarding inclusion of GST or otherwise ought to have been cleared before participating in the bid. Instead, the petitioner chose to participate and is questioning the terms in the tender document after securing the contract and executing the work. It is settled law that after participating in a tender process, the cannot turn around and challenge the conditions in the bid document. Even otherwise, the factual disputes involved cannot be decided in the petition under Article 226. Now, the fundamental question now on maintainability of the petitioner has not addressed the court. However, now I will still go ahead and in my submission respectful.
Right, was only to know the relevance of that exemption notification.
Now, the conscience of this court, I will even address that. The Lordship should say that he is exempt. Now, it's an admitted fact that what, even as per respondent number 3, that the tender is for the right to collect human hair. That's the case of the petitioner, that's the case of the respondent 3 and our case. Even the tender says so. What is exempted, the notification of the petitioner relies upon, is goods. So it has to be the sale of hair. What is the tender for? It's a right to collect human hair. So your lordship will first have to say that this right to collect human hair is not a service, it's a good, which will be incorrect. Because once there's a right to collect human hair, I'll put another scenario. Let us assume for the moment goods sale of hair was not exempt. Then would the right to collect human hair also be levied with the tax? The answer is yes. Because that's a service. Sale of goods. So if the entity itself had sold the goods, it was exempt. Once it does not opt to do that, it transfers the rights to somebody else. The exemption goes.
What? Transfer of what?
Rights to collect the human hair. Not
just collecting of human hair. You are literally disposing of the human hair collected at your premises. You are in the sense of the temple premises.
Yes, Lord. Neither do I know the value of the hair at that point. Nor am I saying this is the price of the hair today, tomorrow. It is for the tenderers to come up with the price saying that I think there will be so much, even if they don't collect the hair. I think there will be so much hair, and I'm taking the rights to come and collect it on every single day or at any given day for a period of 1 year. But there is no ascertainment of that exact amount as on that day.
That's as good as a sale. That is as good as a sale because you are floating a tender for a period of 1 year to the entire quantity of the hair that would fall on in the premises.
So that what quantity is question I ask myself. When we say quantity,
you are not permitting him to remove or collect the tape on the number of trips. Then we could say that he had only the license of transportation of those things.
To the contrary, as not had he come saying every day I'm going whatever hair I collect, I'm giving you like for every day whatever hair you collect, you pay so much. Based on how much ever hair is collected, this is the price of hair.
Not every instead of every day you've said it for 1 year.
What,
instead of having that procedure frequently, you have done it for 12 months.
now in COVID period, for an example, there are 2 years.
No, this is a continuous process, not just that.
Every year.
It's a continuous process.
Now, for instance, what would have happened in the tender where the right was there and there was no hair, not would the person still not be liable to?
That is his risk.
Yes.
That is his risk.
Because it's only a right, it's not a sale.
No. It's in fact a purchase. But so far as he is concerned.
Lordship has put that it's a risk. Now, and if what it on this outright sale, there is no risk because I know I'm paying for.
Why I said it was as his risk that it is not necessary that the quantity of hair that would fall in the premises in a particular year would remain constant. In a given case, it could be substantially reduced. In a given case, it may have enhanced substantially.
Correct.
If we look at it another way, principal will continue to have some interest that is licensed for the goods. Should have the interest, continued interest. But whereas here, after the collection of hair, the entity is not having any stored hair. So it must be considered as sale of goods only. Can't it be that way?
Not right, the analogy is very sound, but when looking at an exemption, now, but that's why I come back to the fundamental question the Lordship will also have to see. Even in the tender notification, it does not say this is for sale of hair. It categorically says I'm only giving you the right to collect.
Correct. We have understood that. What I'm saying is that if you collect 18% interest, tax at that point of time, even if you exempt him at a later stage when he sells it to any XYZ, so far as the department is concerned, you have already got 18% tax.
That's a theory.
Then what is the purpose of having this notification of exemption? Where is it exempted? In any case, it would not be exempted on every sale. You'll be only taxing them once.
Correct. that by looking at an exemption, or that's exactly what I'm trying to submit, what I'm trying to establish, that the logics are saying that either way, when he sells it, now, what the petitioner may not also sell it, whether he sells it, because we're not looking at it as it not being here for a moment, and it means something else. And I was giving an example here also, that now if I put it another way, that hair is not exempt. It's liable to be taxed. Then would this right to collect the human hair, then would it be leviable or not? The question to that is not, it's still leviable because this is a service. The notification is specifically for the good. It is not a service. So even like royalties, etc., lordships you see like minerals, etc., where you get a royalty in addition to whatever minerals you extract. They're two separate things. One is the service, the other is good. Therefore, they cannot be both looked at in the same because the underlying reason on what they are for. And that is what the Honorable Supreme Court also said, not somebody finds an exemption. They squarely have to fall within it.
They have a notification, human hair being specifically notified in that. What more is required? There's absolutely no vagueness in that notification.
Yes, but human hair, which is good, which is sold, but what is it the good that is directly being sold? I'll make my submission and leave it. All that is happening here, the temple themselves say, I'm only giving you the right to come and collect the human hair over the one.
Let us pause there. That is where brother has put a question as to, in that event, you would still have had some interest on that hair that was being lifted by the petitioners. It is not so. The moment the petitioner lifts, you lose your right over that property.
But that's in case of all other such rights which have been auctioned.
So therefore, it has to be presumed as a sale.
So I'm saying in other rights as well, services, where I'm saying that even other rights and services, even that is the same. We lose once you auction the rights, then you have no control because you auctioned it. Even other cases of services as well, not just
What has happened here also.
but that it still continues to be a service. You'll be taxed as a service.
When does the petitioner get an advantage of this notification of exemption?
The person who would get an advantage of the notification is the person who sells the hair.
The petitioner, of course.
When he sells it, he will get it. But that cannot be taken to mean not there is a theory of revenue neutrality the lordship knows.
Oh, but then he has already paid tax. When the hair was being lifted.
My submission is this, but he has paid tax for the rights to collect units of service. Yes, and who has paid tax? It is R3 has paid tax. He in turn contracts with the petitioner that since I am going to pay, I'm entering into a contract with you that you will pay this too. He chose to, he opted to.
No, that ground of yours we have accepted.
So it's not the petitioner who has to pay. The petitioner could, assuming R3 said I take that burden, for instance, I take the burden to pay the tax. Petitioner would still be exempt had he sold the goods later. R3 pays the tax for the rights to collect human hair. When the petitioner has the human hair, he sells it, he will be exempt.
Can we say sale of goods? Four, five,
Sale of
three,
goods.
4, 5.
Put up sale of goods.
Yes, section.
4, 5. House sale is to be.
Application of provisions of the Act for sale and agreement to sell. Section.
Sale of goods is a complete set of.
Can pass on this.
Just read it out.
Sale and agreement to sell. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. There may be a contract of sale between one part owner and another. Subsection 2, a contract of sale may be absolute or conditional. 3, where under the contract of sale the property in the goods is transferred from the seller to the buyer. The contract is called a sale. But where the transfer of property in the goods is to take place at a future time or subject to some condition thereafter to be fulfilled, the contract is called an agreement to sell. 4, an agreement to sell becomes a sale when the time elapses or the conditions are fulfilled, subject to which the property in the goods is to be transferred.
See this situation in the right of.
From my understanding, we fall under 4, subsection 4, an agreement to sell. An agreement to sell becomes a sale when the time elapses or the conditions are fulfilled, subject to which the property in the goods is to be transferred.
You're transferring it. The moment he comes and lifts it up, it gets transferred to him.
When the time
So you are getting the payment.
I get the payment today, the goods go until 1 year later.
Correct.
Then this application will not. An agreement shall become the sale when the time elapses or the conditions are fulfilled, subject to which the property in the goods is to be transferred. So this is happening every day in this case for a period of 1 year.
Is not fine. Is it part? Instead of using these conditions in bar by. But is it done?
But it can be done, sir. Now, in the GST, we look at it like whether there is a supply of services, a supply of goods. And the supply of goods would be the sale, like your lordship has pointed out here. If sale of human hair. Now, I was giving another example, not your lordship, for instance. Now, R3 does not transfer the incidence of tax to the petitioner because he is liable to pay tax because it amounts to a right to collect human hair, which he is benefiting from. That right. Then the petitioner sells the hair. Here the scenario comes in because R3 has transferred the incidence of tax, the burden, to the petitioner. Had he not, for a moment, had he not transferred that right, had not transferred the burden to be paid by the petitioner, then, my lord, the petitioner would have never paid for that. The exemption would be applicable to the petitioner. Now, because R3 says that since I am liable to pay for the right to collect, you're transferring the rights to collect human hair, I'm entering into a contract with you that you pay this tax, which is a service tax.
The moment he lifts it from your premises for the continuous period, moment he lifts it, he gets the exclusive right on that good.
Yes, subject to all the tender terms and conditions.
That is only so far as payment is concerned.
Payment including and the very including the payment of the GST.
Correct, correct. What we are saying is the moment he lifts it, he gets the exclusive right on that one.
Yes, ma'am.
Will it not amount to a sale then? You are losing your interest in that good. He is getting the right on that property.
Yes, the right to collect. The right.
Not just right to collect.
Yes, ma'am.
Right to do whatever he wants with that.
He is getting it.
Yes. And you are losing your right.
Yes, ma'am. I'm losing my right.
You in the sense the temple.
I'm losing my right. I'm losing my right on that property. That's why.
You are losing and he is getting it.
Yes, sir, that's what my submission says.
Then that would amount to sale. You are getting the consideration.
From the terminology taxation, once you say it's a right, he's getting a right. That's what I'm saying. The tender that says it is a right to collect.
Right to collect for what? It is not just for transportation. It is not just to hand it over to some third party.
Again, when I make this submission, I'll leave it, I'll not proceed, but in a taxation statute, it has to be looked at very strictly. Now, supposing if I sell it directly, the entity here, so that there must be some wisdom in why it is always looked at that way. So, had the temple themselves sold it, they would have got some exemption, maybe donations, they will have a trying to go through at what stage it happened, even the Prasadam statute that is given, not even that was exempted. So these exemptions were attempted to be made to the temple when they're doing it directly in some form of donation, etc. It was never attempted that somebody else, they are not doing it themselves. They're doing it in any other way. Then the exemption goes. Earlier it was taxable. I think in 2020 or something like that, there was discussion between the state government, in fact it was the minister.
Would remain that the duty is a license or sale.
Yes,
If that is answered,
yes,
it is only a license, then department can
absolutely.
it is there. This has to come.
Correct.
The exemption has to.
And that agreement to sell subsequently, so there's no agreement to sell. They're not telling him later that he can sell it or. And your lordship is right, but once your lordship find it's not licensed. Lordship have to come to that finding only after they say that we have given a license for them to collect it.
You are the Sale of Goods Act, Section 5(2).
Subject to the provisions of any law for the time being in force, a contract of sale may be made in writing or by word of mouth or
We will pause at every or writing or by word.
subject to the provisions of any law for the time being in force. A contract of sale may be made in writing or by word of mouth, or partly in writing and partly by word of mouth, or may be implied from the conduct of the parties.
Last part. Implied by the conduct of the parties. What when we said that you are losing your right and he is acquiring his right. On that.
Not the analogy and not clear in the position of lot of royalties and rentals for it. So there what would happen? This analogy is to be adopted there. That would go, they cannot charge royalty because you're anyway, it's on the same mineral which you're extracting from the earth.
No.
On this hand,
What is worrying us is that there is an exemption of 2017, which says human hair stands in whatever form, stands exempted from payment of GST.
the answer will
Now, what is not directly permissible, you are bringing it under the ambit of a service and trying to collect GST.
in that case, the respondent 3, if it finds that it is now being unduly taxed on something it shouldn't, it can sell the hay directly. Why does it still opt to do it in this manner?
It is in the form of sale. That's what we are trying to bring it under the.
That's what I'm saying. But if R3 says that, it says no, now this is not a license to collect human hair. Whatever the quantity of hair that's collected, you will be charged based on that. Supposing in every 6 months, they're going to calculate this is the amount of hair. Or at that extra, they have to do for the exception.
please read A1 also. I1.
Contract of sale, how made? A contract of sale is made by an offer to buy or sell goods for a price and the acceptance of such offer. The contract may provide for the immediate delivery of goods or immediate payment of price or both, or for the delivery of payment by installments, or the delivery or payment of both shall be postponed. But when reading this section, not may I read it out again and I'll pause the relevant. A contract to sale is made by an offer to buy or sell goods. Now, till there it's fine. Let us assume it's buying or selling hair. For a price and the acceptance of such offer. Now, if this goods come, they
For a price or an acceptance of such offer,
offer.
the offer is what, in your case, the tender. You say that whoever would quote the highest would be getting the best.
Yes, but that is where this has to be now this application of that buy or sell goods at price and the acceptance of such offer. The offer will be when it's goods, not these are the goods. It will naturally follow that it is ascertained what are the goods, the quantity, the description, everything.
Not necessarily always, the quantity is definitely not. Like even when you look into the other contracts of purchase of scrap from
Yes.
steel plants,
Yes,
there are certain scraps which are released every day. They don't sell it. They, in the same way, they issue a float a tender and they say that whatever scrap is accumulated for the period. Previous 3 years, this was the accumulated quantity of scrap. It's an approximate. This year also, whoever quotes the highest. So they take into account the scrap that was received for the past 3 years or 5 years, and then accordingly they quote.
there's some estimation that this is the manufacturing process.
Do you think the persons who quote do not take into account the quantity of they do that? There are certain contracts, the quantity is not fixed. It can vary. And therefore, they tailor the tender conditions accordingly.
But in these contracts, not it will obviously be that it's a direct agreement here as per this, where you say, I am selling you these goods, and this is the price based on so and so, how many ever years, so you can quote it, but this is what we are doing. Here, they don't get into that aspect. The R3 only says, I'm not looking into any of those. I am outrightly only saying I'm giving you the rights on whatever hay that may be tonsured this year. And so they're not looking into, I'm selling, at no point they say, I'm selling you hair at this quantity, this thing, rights to come to our premises and collect it. We are absorbed post that. Because it's on a lot of factors, people coming to the temple, things change, but so that it's very, to put it in that kind of a scenario where there's some sort of ascertainment that can be made, in this case, cannot be made. So these have to be looked at only as rights to collect human hair. And my respectful submission is not in a taxation statute. When something would fall under a service, an exemption to a good cannot be the underlying reason that there is a exempt, the good is exempt. But since this rights are always in terms of services, the petitioner will have to show that even that service is exempt. The right to collect human hair also is exempt. That is not available, but not in their exemption notifications, even for services. Like in good, not just find the compilation, there's to show your options that those, their rights, etc., also which get exempt. The notification 12 and 11, which are like,
Look at notification number 2.
that's for good.
Intrastate supplies of goods.
Good then.
And it is that good which you are permitting him the right to lift.
Yes, no. That good which I'm permitting the right to live, but the right is not the supply of good. The right is the service. Once it is a right, it is a service.
It is supply, how do you say?
Supply of good, not right.
Yes, whatever hair is that is falling in your premises. They are giving him the right to live.
These are rights, not that, like logic thing, schedule, etc. in the act, whenever it is a license, a right, all of these are services. Goods are the actual goods. I'm only giving a right for him to collect it over a period of time, whether he collects it, not collects it. Anyway, I will read the counter, not is very aptly put by R3. I read the counter of R3 and what they say. Because R3 also is with the respondent number 4. And that also has to be looked at, not because your logics are looking into something that
There are not this maintainability issues in there.
Not just that. And RP themselves say, yes, we categorically consider this to be only a right. It is not a, it's a service. It is not a good. And we are liable to pay 18% GST, and we are once liable, and we have contracted. At all, they have not even said in the event the court finds that it is not, or reserve their rights. They are very categorical in their submission.
Then why charge? But then there was a need for a consideration for the granting the right to live.
So R3 is not being run. I'm not
This one, we were trying to think loud.
sorry.
If you say that it was only a right which is being given for the, to the petitioners to lift the dead,
Yes.
then where was the necessity for the temple authorities to have put a consideration for that lifting?
Like in all other rights, you also have heard the transfer of development rights, all the other rights. But there is,
It is there. You are saying it is only a license.
and
We are looking at it as a right in the goods. Transfer is there. Transfer of right is there. The fixed. And the fixed and the license are same.
absolutely, no, that is the question your lordship will have to say, if the lordship is, or you view that.
See, you were not, you in the sense, the temple authorities were not interested in any revenue from that.
Correct, no, that's, yeah, there are two ways of looking at that. Since there is a consideration, the 80% can only be on a consideration. If they did not take any revenue, the question of paying them tax on the rights to collect human hair, not since they are
Revenue of what?
of human hair and coconut shells. In
Total.
in this case.
In total, not just for the transportation of that. You are giving the right of that goods also which he would be lifting.
Yes, and I complete agreement that we are giving the right for him to collect this human hair and coconut shells and do whatever he likes with it. But end of the day, like Lordship said, posed question that these the temple authorities are not outright selling it; they are only selling, making a right. That's only a right for the purpose of this act. Not whenever it's a right, license, etc., it's a service. Even if it is a good, I gave another example. The Lordship would have to look at it the other way. If the good itself was not exempt, then also they would have been liable to pay tax. The Lordship is looking because anyway it was a good underlying good.
If it was not exempted, obviously it would have been taxable.
The right as well as the sale of goods.
Both.
Both. If the Lordship is of that technology, then the answer is both good. Just because now the sale of good is exempt, the right is not exempt. So they're two different things. May I just read out the counter of RSA? You bring like
Which page?
these counter not start with page 36. I'll not read out the entire counter, only the relevant paragraphs.
Paragraph?
3 minutes.
Yes.
So this is the gentleman. Their count. It is submitted that this respondent options the right to collect the human hair and broken coconuts on an annual basis for which tenders are called for from the interested parties on finalization of the tender, the amount offered by the highest bidder is approved, allowing him the right to access to the temple for collection of human hair or broken coconuts as the case may be. It is submitted that the respondent issued, now this is what they say. They are also putting it in that manner. It is submitted that the respondent issued an auction notice for the period of 1/8/2021 to 31/7/2022 for the collection of human hair from the temple premises. One of the conditions in the tender notice is that the successful bidder has to pay 18% GST as per Central Goods and Service Tax Act 2017 and State Goods and Service Tax Act 2017, here referred to as the Act, in addition to the bidding amount. The respondent clarified that the GST is applicable on the transaction of auctioning the right to collect the human hair at 18%. This respondent, and this respondent will incur the liability to pay GST on the amounts received as consideration towards auctioning the right to collect human hair in terms of the provisions of the Act. The transaction of identifying qualified tenderers and accepting the bid of the highest tenderer for collection of human hair is a transaction of service as defined under section 2102 of the CGST Act, which reads as under.
It appears that the reply for the technical authorities also have been prepared by the GST department.
When I read, it's far better than our own count also.
That is what you were discussing.
Here they have taken some from the senior counsel's opinion and they have put that in the form of a counter because it is very aptly and articulately put. That's the reason I'm not relying on my own counter of the departments. There's even better put over here.
Yes.
Services means anything other than goods. Money and securities, but including activities related to the use of money or conversion by cash or by any other mode from one form, currency or denomination to another form, currency or denomination, for which a separate consideration is charged. Explanation for the removal of the hereby clarifies that the expression services include facilitating or arranging transactions and securities. And read para 4 as well. The petitioner having agreed, because that comes to maintainability issue. The petitioner having agreed to the terms and conditions participated in the tender and became a successful bidder for the period of 2021 to July 2022. The petitioner has collected the human hair for the period of 21 to July 22, paid the entire bid amount of 1,40,20,200, but refused to pay GST of 18%. In a sum of rupees 25,23,636 to the respondent for discharging this statutory liability payable under the Act. The payment of 18% tax on licensing services for collection of human hair is a statutory liability of this respondent, and it has the right to recover the same amount from the consideration of the petitioner. However, the petitioner, being aware of the liability, is dodging the payment of tax amount. Then we have para 6.
Yes.
It is further submitted that the claim of the petitioner in the letters dated 11/7/2022 and 28/7/2022 that human hair is exempt from GST by the central and state government by HSN classification number 0501 is not sustainable and applicable to the facts of the case. While human hair may be exempt from GST by serial number 30 of notification 2 of 2017, central tax rate dated.
This was for the period from August 21 to July 22.
Yes, ma'am.
What about the previous years?
Continuous.
No, previous years.
No, previous year is not mentioned. You're not petitioner. In this case, we are.
Petitioner maybe if at all if he was the successful bidder. If somebody else was the successful bidder.
Subsequent year, they say that they have it is imposed on them. The subsequent bid as well, it is imposed on the successful bidder. They have said so on the contract.
No, what about the previous years?
Previous years, I am not aware. I did not think about asking about that.
This notification that is being relied upon is of 2017.
Of 2017.
What was it really paid from 2017 to 2020?
What I suppose would have happened was the GST department would have issued notice, then they would have paid the tax. And henceforth included in the tender terms and conditions that since we are liable to pay tax, that you will be liable to pay the previous year. That is how they probably woke up to the 18% GST.
Yes.
And it, para 6, I'll start again now because they refer to this notification 2. Because notification 2 pertains to goods. Again, in further submit to the claim of the petitioner in letters dated 11/7/2022 to 28/7 that human hair is exempt from GST by central and state government by HSN classification 0501 is not sustainable and applicable to the facts of the case. While human hair may be exempt from GST by serial number 30 of notification 2 of 2017, central tax rate dated 28/6/2017, the transaction for which consideration is received is for the right to collect the human hair by giving him the license to enter the premises and lift the human hair offered by the devotees on tonsure, but not sale of human hair as covered under serial number 30 of notification 2 of 2017. Central tax rate dated 20/6/2017. At the time of auction, this respondent is not aware of how much quantity of human hair would be available during the period of August 2021 to July 2022, and what is the quality of human hair and the price it fetches in the market. It is for the petitioner and other successful bidders to estimate and assess the nature of business and determine the bid amount. This respondent is entitled for payment of the entire bid amount along with the GST payable thereon, as the GST amount is a statutorily payable and also agreed contractually. Having agreed to abide by the terms and conditions of the tender, the petitioners cannot turn around and wriggle out of the contracted obligation by claiming that human hair is exempt from tax, ignoring the fact that the transaction is not in the nature of supply of human hair, but having the right to access into the temple premises for collecting the human hair. And also what is important, they themselves say that we do not know the quality of human hair, we do not know what will be the quantity. So this is all abstract. It is for you taking that risk. So that quantity, we don't know the quality of the human hair because all that changes to that. That's why they say it's a right. You collect it, what it fetches in the market also we don't know. So it cannot be assessed, with all the other contracts the lordships are also looking at. In those cases, some kind of certainty is there. You can look at the manufacturing process. But here the temple itself says so that we don't know what is going to be the quality, quantity, or what is going to fetch in a particular. And a lot of other factors also are in play. Now, can we para 9?
Yes.
Reply to para 5 of the counter after this respondent submits that the option called for on 20th/7/2021 for the right to collect human hair for the period of 2022 to July 2023 also required the bidders to pay the GST 18% to the third respondent. This is the question your lordship posed me. That has also been answered. So now it would be even those people would have to, they have not challenged it or questioned it, because it's part of the tender terms and conditions. Then references the continuation of the paragraph to the previous petition. I'll read that for your lordship. This time the petitioner appears to have challenged the condition in the writ petition so and so before this honorable court. Though the honorable court permitted the petitioner to participate in the tender and directed the respondent not to finalize the tender process, the petitioner did not participate in the tender process and consequently the writ petition came to be dismissed on 7/12/2022. The conditions raised inside the petition have nothing to do. This is the writ petition or subsequently the subsequent tender. In para 11. Yes, this can be all these paras which I am referring a lot can be also in my arguments. Recorded, if I will put it, I will put it like this.
Not the argument of the temple of the.
As well as there, now it becomes very easy for me because the temple authority themselves are categorically not saying that we are liable, this is a service. It is for them to come before this court and say, no, this is the sale of goods and answer all, and then I'm supposed to answer all of the lordship's questions, but they themselves say no. Para 11. The response to para 6 of the writ affidavit, this respondent submits that the categories of transactions mentioned in Schedule 2 of the CTST Act, the section I was referring to during argument, of 17, as to which transactions should be treated as a supply of goods and which transactions are to be treated as supply of services, does not cover the instant transaction between the respondent and the petitioner. The transactions listed out in Schedule 2 are identified statutorily either as supply of goods or supply of services, and the treatment of tax liability will depend accordingly. The petitioner's contention that human hair falls under the transfer of title in goods and hence it is a supply of goods may be true, but what this respondent does is not supplying human hair. It is calling for an auction for a right to collect the human hair from the temple premises, which is distinct from the supply of human hair. When the respondent calls for a tender, the value of the human hair is not ascertainable either by quality, quantity, or the rate. Hence, there is no ascertain goods for supply to the petitioner.
Yes.
13. Many of the lordship's queries have been answered as well now. In reply to paragraph 7 of the affidavit, it's not necessary for this respondent to maintain maintainability. It is not necessary for this respondent to contest the matter before the fourth respondent. Since even according to this respondent, the liability to pay GST arises on the subject transaction. Having taken a conscious legal stand after advice, this respondent has insisted on the payment of GST at the time of participation of tenders to which the petitioner has consented and participated in the tender. Having agreed to pay the bid amount and the GST thereon, it is not open for the petitioner to dispute liability towards GST without any legal basis. Now, then in paragraph 15, the claim that this respondent has not collected GST or at 18% from the highest bidder who was successful in the tender published on 12/7/2021 for the right to collect human hair for the period of August 2021 to July 2022 is denied because even in the fresh tender, such a condition of pay GST was existing and the successful bidder agreed to pay the same. Then in paragraph 16, the second ground of maintainability. The writ petition is misconceived and not maintainable in law. The prayer sought for is contractual in nature, for which the appropriate remedy is civil suit, but not for writ petition. Because that becomes contractual. The first was who can challenge it, then the participation of the tender, therefore he cannot challenge the conditions having participated. Third, it's contractual in nature. For all of those, it is not maintainable. But then in the relief in the last prayer, the petitioner asked for interest in the R3. Therefore, the writ petition may be dismissed and the petitioner should be directed to pay GST amount of so and so, 25,23,636, along with bank interest on the date in which is due till the date of payment, because they have been deprived of they paid the department and they are deprived of the 25, so they are seeking bank interest. Because the petitioner having agreed to the terms, it amounts to 20, enters the tender, he doesn't challenge it. He says, yes, I'm agreeable to this 18%. Then after he is a successful bidder, then he turns around and says, no, I'm not going to pay.
No, not then also. He collects it for the whole year.
Yes, ma'am.
And only when July 22, when his contract was coming to end, and then he raised that issue.
Correct. So, very difficult maintainability itself for the petitioner to overcome, which is why we're trying to urge before your lordships that first that will be, and the rest would be an academic issue. But now, lordship, even then, the respondent 3 who is liable to pay the tax has categorically said, yes, we are liable. We have no doubt. We are not going to challenge it with the fourth respondent. And they categorically say what they are doing is a right, which is a service. So we are not in view of that. The rest of the arguments raised that the petitioner will not hold good. And there are separate notifications for exemption of services which I have filed just for the sake of showing the lordship that the notifications for exemption of goods are different, and notifications, there are separate notifications for exemption of services. There's notification 11 and 12, which have also been filed. And the judgment, finally, the judgment which I have. The lordships have already seen this judgment. Yes. It says
that in the event of there being any ambiguity,
any sort of ambiguity,
exemption sought for has to be very specific.
Very specific. Here, if there is an ambiguity whether it's a service or a good, where RP has also said very clearly, we also are what we are providing. They are the provider of the service. They themselves say we are providing a service. And in such a case, they say that's not an exemption. That's not exempt. Then that judgment would get attracted and saying there is an ambiguity, and any slightest ambiguity also that they always was in favor of the department, saying that there is no exception. May I read out this paragraph?
Will that not render the notification to be redundant?
No, I was pretty clear also about that. As the temple itself, they can change their modus. Look, even next year they're doing it the same way. They're still doing it jobs. They're away now. It's 18% for the right. They can suffer that tax for 1 year. Next year onward, they are fully aware. Watch the scene they counter. They understand the scheme of the act and goods and services very well. They can say, okay, goods are exempt. I'm going to only sell it on a day-to-day basis or weekly basis. I will collect the hair for 1 week, 2 weeks, and sell it every week. They will be exempt. So this notification is not rendered redundant in such a case. They can still fall under the notification if they want to. They are categorically opting not to. They don't want to take that burden of the headache of counting, keeping their hair, storing it. They're just giving the rights to somebody else to do whatever they want with it. If they want the exemption notification, they still can avail it. But tenders 1 year. 1 year they have paid tax. The following year they can change it. They can themselves undertake to keep the hair, sell it in terms of quantity, quality, all of it. And they'll be exempt.
For the subsequent year, the GST is being paid.
Yes, they say so in their contract.
Yes, what do you say? So far as the objection of maintainability is
But
concerned.
the maintainability, the reputation is concerned, the maintainability of my reputation is very much maintainable because now either the third respondent or the fourth respondent, it is not a contractual obligation. So therefore, the question of maintainability of reputation doesn't exist. I am seeking intelligence of the Samba Court to declare the action of the third respondent insisting payment of GST at the rate of 18%, contrary to the notice issued by the central government is bad in law. That is
Why was it not challenged when at the time of when the tender was floated?
Yes, my instructions are that there is no condition as such in the relevant period.
Where is that?
It is neither supplied by me or supplied by the third respondent temple. It is only mentioned the subsequent year. Therefore, I filed the petition. The condition for payment of 18% GST by the auction purchaser is not there, was not there in the relevant the auction notice. But it was there in the subsequent year. Therefore, I consider to file the petition challenging that condition.
The temple authorities have also filed their counter.
Yeah.
In the counter, they have taken a very specific stand that this was a condition inbuilt when the auction notice was floated.
Yeah. They only say that it is a condition.
Now it is your writ petition. You will have to show that it was not part of that auction notice at all.
Yes, Millard, my respectful submission is that my instructions are that there is no such condition in the imputed notice. In the notice, blood inviting debtors blood for collecting the hair. It was there, blood subsequent year. Then I agreed, I filed the petition challenging that condition alone. Since I could not participate, my petition became dismissed. I stated so categorically in my writ of petition. At para 5.
Is it so?
No, that's the petitioner was participating in a tender. You will look at the tender conditions only and participate. It's not filed here. Saying he doesn't have the tender condition. And page 14 of my issue. Page 14 is letter with a refer to the clause. Is a letter of the Devasthan. But please see the third line. I'll read the entire. I hereby inform that so and so Human Hair Enterprise Hyderabad, the e-tender publication was conducted on 28/7/2021 for collection of human hair for the period of 18/1/8/2021 to 31/7/2022 on payment of GST by the highest bidder for an amount of so and so. You had informed that the amounts already paid for collecting human hair for the period of 1 year, i.e. 1/8/2021 to 31/7/2022. You have agreed to pay the GST of 18%, and GST is not paid. The human hair is under the custody of the Devasthan. As per tender condition 25, you have agreed and signed for the payment of GST, but did not pay GST at 18%. A condition is also mentioned here, but in the counter also they say so. In the reply, he doesn't say there is no condition in that reply letter, which is the next page. He only says I'm not liable based on notification.
But even assuming if he losses Even assuming there is a condition, that condition imposed by the third respondent by ignorance of law. So therefore, when a law is specific, ambiguity, the third respondent or both respondent are not entitled to collect GST.
But you had accepted it with wide open eyes.
No. That is
When you quoted the price also, it was there.
even assuming that have admitted for argument's sake, they cannot take away the notification issued by the government for exemption. They cannot for claim unjust enrichment.
Yes.
That's all. I'm aware for reading the cost of my other letter press. Right?
That they will deal with you.
Maybe from a complete mention.
Yes.
Not victims. But 28 is for the state government to respond for that. But 34 to 38. I inform the other side, but I'm not informed. I'll leave my colleague here, not chief matter reaches every time.
For counter.
No, not coming up for admission. It was a question your lordship posed that to show that there is a delay in filing question has been taken adjournments in the last few days. That you agree to argue. Very well.
Hey.
Next matter. Next matter.
25.
Next Monday, we'll have it.
Not next Monday because Monday is national holiday. Wait, after Diwali.
14th.
That week is already packed. 21st, 22nd?
21st.
21st, 25th. The contract of the 21st of
Item 40, I'm only requesting for tomorrow.
who's there on the other side.
I'll inform him not here post and have a difficulty. I think that may reach for that. You're requesting for tomorrow.
Provided the other side is there.
Then very well. I'll come to my time.
next week.
39.
29. 29. Sorry. 29.
29. Not now, all goes in December. There's a difficulty this week. 29, can we have it December first week?
Next week, any day you want.
That's what he said, first week of December.
And 32 of
7th of December 29 at the request of C so and so and the instructions of so and so. Yes.
I do 32 not. We need to file the claim.
32.
32.
32 you are for
Petitioner.
reply to the counter.
Inform us.
32 at the request of the council for the petitioners to file rejoinder to the counter filed by the department. This case on the 10th of January.
In item 40, the inform the council is here.
40 Monday.
Only for tomorrow.
Tomorrow.
Because the informal is the response to the respondent is not available here.
Yes.
Tomorrow or day after.
Yes.
Yeah.
May have it tomorrow or it's
Day after tomorrow.
say
40 day after tomorrow. The request of the council for the department. Yes.
We have 49 my lord.
Yes. What do you want?
230 my lord. Regularly I am coming my lord. 49.
49, wait, just wait. There are few matters. After that, it should reach. Just wait for it.
Then
Yeah, after this,
Silence.
Minutes time for the respondents' minutes.
You mean the compensation mirror where the claimant has given 30 lakhs for the transport and only 50,000 is granted mirror. Totally, the entire evidence is vested as stating that they are only simple injury. Whereas the claimant was in hospital for 15 days, in an emergency situation, he was shifted from Kottagudem Single College Hospital to NIMS. And here Miller, operation was done and he was in as inpatient for 15 days. Not to kindly see the screen facts of case Miller show. Then record is not available in the
What was the nature of injuries?
fractures Miller.
How many?
There are 3 fractures Miller. First was given in activity is 6 Miller. Clearly, the doctors.
Minutes, the injuries were enumerated by the lower tribunal at page 7, para 12, middle minutes.
The operations for left shoulder behind and outer. So left side was the foot and fracture LP cervical, previous in nature, fracture left to previous in nature, fracture left to cervical bone skull, previous in nature. With all these minutes, the current is left is saying that they are simple in nature. To take 6 minutes, it was given by single college company doctors. And later middle it was dismissed from service, giving job to his son on medical ground. Now London says only for purpose of securing job to his son, the certificate is created. And he got nearly 14 years of service left Miller by the time. There are 2 documents. He was a whole citizen in single college. We filed official document. No Miller, not telling. And make a paper with Miller. Most of the documents are available.
are the aspects disputed in this? Are the aspects here disputed in this appeal?
Their total entire evidence is discarded. The medical certificates, doctor's evidence, and learned says they are simple in nature. Let me kindly see internal page 9 of the judgment mirror. That is second paragraph. At this stage, the pertinent court appreciate the entire procedure.
Did you examine any doctors?
Yes, sir.
Who's
The
that?
doctor is the PW3, who is the single doctor gave certificate, Dr. Prasanna Simha. And
Did you get any disability certificate issued from a medical board?
X1 to X6. Attested copy report of corporate medical board.
What is the percentage of disability?
Bone fracture, cervical bone fracture, it could not sit properly. Therefore, medical board discharged him. You are dismissed from service, giving job to his son. Collar bone and also ribs, 5 ribs.
Fracture of ribs would not lead to any disability as such. They get healed up automatically.
Because the whole pillar will not exercise is only with the hand. Therefore, they are discharged from service.
At your request.
That is,
Otherwise they would have given you an alternative employment.
no, if you like to get it, they refer to
Hey.
medical board.
Under the service rules, if he is not in a position to do strenuous hard labor, he would have been given a light duty.
The only 4 pillars in the what?
That's what he would have been given a ground duty job.
He was referred to medical board, medical board opinion that he cannot do any work. Therefore, they have discharged him and it's all appointed. When there are fractures, the doctor certificate is there. The learned said they are simple in nature.
Where is the statement of the doctor? Medical board? Not there. Has it been discussed by the trial court?
I will have to say page 9 of the judgment. PW3 was after someone they got exhibit 821, which is authorized shows that PW was authorized to attend court. Exhibit X1 is noted, which is aware of this, that he is on medication, and it is also noted that if he is the offense of corporate medical board, and it is noted he is unfit. Exhibit X2 shows medical certificate that is suffering from right temporal confusion.
No, read the first paragraph of page 9, internal page 9.
Yes, sir.
The top part.
After
Therefore, after the
accident, it is not to join service and prefer to take it and get his son.
that was his voluntary act. That was his voluntary act.
That was voluntary. He afraid because could not work. He afraid from it.
Now read further.
Yeah. This was clearly spoken by PW2, who is the employee of England College.
Correct.
Further, PW2 entry clearly says they have not acknowledged petitioner medically. Added to this, PW3 clearly says that at NIMS, during the treatment and discharge, he was not found with any disability. As such, there is no disability to petitioner. It is plain that for a fracture of ribs and cervical bone, a person would be declared unfit in the service. Basic on this period.
What is-
claim
Correct. PW3 you said was a doctor.
Yes, sir.
PW3 said that he was not found with any disability as such.
Yes.
There was no disability to the petitioner. How do you come out of that?
Disability part is not claiming only with regard to injuries.
Unless there is a specific disability established, partial, permanent, or partial permanent, whatever it is, there has to be a percentage of disability that has to be.
The X6 is the case sheet and also mirror the report given by the NIMS. It clearly says operation was done on him. He suffered fractures and nothing was disturbed. No compensation paid towards.
See, merely because he was. Mainly because he was subjected to a treatment in a particular hospital. He underwent a surgery as well.
Yes.
That by itself would not lead to a physical permanent partial, permanent or partial disability.
Even 100% is not able, but the fact that means that he suffered accident.
The treatment part must have been reimbursed by the employer.
Yes.
Under the service regulations. So that part also you would not get any compensation. Here is the scope of enhancement.
Not to get pain and suffering and also.
That has already been taken. That has already been taken care of.
Only 50,000 of that is as the claim of 30 lakhs.
But that was not substantiated.
Last week, can you see, is a four pillar because and no person will leave the job or leave 14 years of service.
Fortunately, his next generation stands secured.
Page 9, brother,
What is the period of treatment?
15 days.
13 days, my lords.
2 weeks. 13, 15, 2 weeks.
Yes, my lords.
Page 9, there are 2. X2 shows medical certificate that is suffering from right temporal confusion, fractures of ribs, fracture of condition on right side, and blood trauma in upper. These are not mentioned diseases. These are not diseases. A fracture will heal in due course. That was the conclusion I left with the court Miller.
Yes, Mr. Counsel.
Millard, sir, your lordship may kindly see the continuation of the very same paragraph, Millard. But on the contrary, Exhibit A6 name certificate clearly shows that the petitioner was discharged from the hospital on such and such on 25/7/2004 within few days, having found that his condition is stable and is progressive and responding to the medicines. Strangely, under Exhibit X2, the petitioner was found to be still suffering from fracture, and these certificates are issued without examination, and as such it is very much clear that the petitioner removed from service is more wanted by the petitioner for the dependent employment than based on any medical examination. Further, it is also noted whether the petitioner is suitable to work inside the mine or overground. It is normal practice that in case of any person for any reason is found not suitable to any job underground, by going inside the tunnel, it is and if it is found otherwise suitable to do ground overground, the person will not be removed from service. Further, even if he is medically found not suitable, he will be given compensation and dependent employment. In the present case, the petitioner has taken all the benefits and chosen to leave the service and now getting pension. Before any person removed from service on the medical ground, it is incumbent upon the employer to, to satisfy what is the physical condition of the employee and what are the infirmities that the employee is carrying, and how these infirmities are going to affect his regular functioning or his job requirement, and why he is found not suitable for any employment in the organization. Nothing was stated in these orders of the Singareni Collieries Company. Therefore, absolutely there is no nexus was shown between the accident and the certificates issued by Singareni Collieries Company and losing of his job. On the contrary, the evidence of PW 2 and 3 clearly indicates that the declaration of the petitioner as unfit is at the desire of the petitioner for dependent employment and getting the person, and to assist the petitioner, these orders were given, and in these circumstances, the tribunal is unable to accept the contention of the counsel for the petitioner that the petitioner lost the job as a result of the accident. Totally, there is no nexus between the loss of employment and the accident. Exhibit A4 is the application. Millard, these are the findings of the lower tribunal, Millard. After considering the entire evidence on record and the pros and cons of the case, that the tribunal awarded about 60,000 rupees as a compensation to the claimant, Millard, for the injuries sustained.
Yes, Mr. Counsel, where is the scope of enhancement? We do not, in the teeth of these findings, this, you should have offered for some settlement before the Lok Adalat long back with whatever little enhancement that the insurance company would have agreed for.
Loss of employment is also Millard.
There is no loss of employment as such. That's what I said. There was a voluntary application made by you availing the benefit of dependent employment.
In Millard, for his injuries and also fractures, nothing but discussed, Millard.
Those have been completely healed up. There is no disability as such. This 2,000 rupees is for
Millard, sir, 3,000 was awarded towards loss of service benefits. I'm sorry, Millard, that is his calculation.
3,000 is for extra nourishment.
Yes,
5,000 towards transportation. 2,000 towards the incidental medical expenses that are
5,000 for transportation. 3,000 for extra nourishment.
3,000 for towards extra nourishment, Millard.
offer something for disposal of the from the insurance point of view.
Millard, you will also kindly consider about the injuries, grievous injuries. Millard, you will also kindly consider those injuries, 3 injuries, grievous in nature, and you will also kindly grant some more compensation towards them.
How much?
Millard, 1,20,000 will do. Millard, it will be in the interest of justice, Millard, for the 3 grievous injuries. More, 1,20,000 more in addition to what has been granted already.
More than what I was expecting.
Exactly. Your Lordship, please. Because nowadays our honorable court is considering 40,000 per each injury. That's why I submitted like that, Millard.
So in addition to the 60,000, it will be 1,20,000 in addition.
Yes, Millard.
That makes the total compensation to 1,80,000.
Millard.
Present is in appeal.
Lords, for item number 27, I am for the petitioner, my lords. My lords, this is an application where the respondent 2 and 3 have been got the compromised 498 years case in the Lok Adalat through fraud. And this writ petition has been filed to annul that compromised Lok Adalat petition, my lords. If my lords go to the page number 12, the proceedings before Lok Adalat can be found, my lords. Page number 12. My lords, the respondent number 2 is the husband of the petitioner number 1, where there was certain matrimonial disputes between them. And as a part of compromise, the respondent number 2 has agreed for a mutual consent divorce in lieu of
Yes.
my lords, the respondent number 2 who is a husband of the petitioner number 1 filed a mutual consent divorce in the family court. And as a part of the mutual consent divorce, the petitioner has agreed to withdraw the family 498 proceedings against the respondent number 2 and 3 in the Lok Adalat, my lords. Page 12 is the Lok Adalat proceedings.
You appear,
Petition.
you appear for the wife.
I am appearing for the petitioner wife, my lords.
You were responding before the court below.
My lords, I am the de facto complainant in the 498A and the joint petitioner in the family court proceedings, my lords. Page 12 is the Lok Adalat proceedings, my lords. If my lords is the terms and compromise, if any, it is clearly mentioned as per the mutual consent divorce petition number 310 by 2022 before family court LB Nagar, Rangareddy district, in the page 12. My lords, page 33 is the mutual consent divorce filed by the petitioner and respondent number 2 in the family court. From page 33, my lords. From page 33, it is a joint petition filed, my lords, under section 10A of the Divorce Act of 1869. As the petitioner and respondents are the practicing Christians, they have filed it under the Divorce Act of 1869, read with the section 7 of the Family Courts Act. And if my lords can see in the bottom, the respondent number 2 has affixed his signature for a joint mutual consent divorce. And my lords, in page 40, there is a verified affidavit. There is a verified affidavit filed by him in the page 40. Where he himself has agreed that he will get a mutual consent divorce. The petitioner, my lords, who has undergone tremendous mental trauma with the respondent, has decided to forego all that, because once the divorce proceedings are over, she does want to start a new life. So she has decided to withdraw the 498 proceedings. And as a part of that, my lords, page 12 is the Lok Adalat proceedings where she has withdrawn that. In page 12. My lords, page 12, very clearly it has been mentioned even by the Lok Adalat that as per the mutual consent divorce petition. So my withdrawal of 498 proceedings is intrinsically linked with the 498 divorce proceedings. But my lords, the respondent who has a fraudulent intentions from the beginning, after withdrawal of my 498A, page 32, my lords, the docket proceedings. Page 32, my lords, the docket proceedings of the family court. After withdrawal of date 13/12/2022, He went back on that, my lords. Page 13, date 13/12 and page 32, last. Both parties are present. Second petitioner reported he was not interested in proceeding further. As my lords, in the mutual consent divorce, even if one party goes back, court cannot proceed. So this petition has been withdrawn. It has been dismissed by the trial court, the family court, my lords. So his withdrawal of the 498A is been obtained by the fraud. And my lords are aware, a fraud vitiates every transaction. So he cannot be the beneficiary of the withdrawal of 498A, my lords. It has to be restored. That is why the wife has been constrained to file this writ petition.
When the matter was settled before the Lok Adalat, both the parties were present.
Yes, my lords, both the parties are present.
You check the record.
But they doesn't say anything that.
It's not legal. Normally, on a date of Lok Adalat, either of the parties have to remain present.
Yes.
And in the docket, they will also be putting their signatures. Whether such a thing has been done in this case? Not yet. Yes. Now,
I
what
have to make a comment here,
Yes.
sir. And FCOP, I told in the court on December 12th.
just before that, there was a case under 498.
Yes, sir. Yes, sir.
You are
A respondent too, sir, Timothy Fernandez.
Timothy
And the
Fernandez.
husband of-
Fine. Yes. So there was a case under 498.
Yes, sir.
That was withdrawn and on the date of
Yes, sir.
12th of November 12th.
Yes, sir. We agree.
You were present there on
Yes, sir.
the.
Me and my mother both were present.
Both were
Both
present.
were present, sir.
It was disposed of in the light of this mutual consent divorce petition.
Yes, sir. I would like to highlight one point, sir.
Yes.
Before five, I would like to tell you an upfront.
Now, just before that,
Okay.
you had also filed a joint petition before the family court for a divorce
Yes,
with
sir.
a mutual
Out of
consent.
Forcefully, they told, we will only withdraw, if you cite the mutual consent.
What do you mean by forcefully?
Sir, in the sense, if
How old are you
no, but one thing,
then?
my lord, on December, what I told was that the date was mentioned was October 2020 was wrong. I told to them, to their lawyer, sir, it is wrong.
It is not that what we are asking. We are asking is, you were being prosecuted under 498A.
Yes, sir.
There was a petition jointly filed with
Yes,
you
sir.
and your wife for a divorce in the with mutual
Yes, sir.
consent.
I accept, my lord.
That 498 also was withdrawn in the
Yes, sir.
light of the consent that you had given for
Yes,
the
sir.
divorce.
Yes.
Then how do you back out now?
On 12th, I have mentioned in the court stating, to the court stating to change the chief because the date was mentioned as October 2020.
Which date?
We were separated only from July 2021, sir. As per, if you see 498, if I'm not wrong, once again, I'll read the page. If you can read para number 21, page number 7 of police case, sir, it is clearly mentioned, page number 7. In paragraph, in the month of July 2021, only we were separated, my lord. Okay, I told this to change the chief on December 12th. Please change the date.
Where? Change the date
In the court, in the family court, sir. On December 12th, I have told in the family court to change the chief.
How does it matter?
So it was, the reason was,
How does it matter whether it be July or whether it be October? How does it matter? When you have decided to mutually get the divorce?
Sir, it is clearly mentioned.
And the other side also willingly withdrew the petition under 498A.
Sir, in the, I would like to make a comment here. In the church, they have said to change it, sir, because we are only separated from July 2021. I've told this to the, his lawyer.
We are not concerned with what transpires in the, what we are concerned is what has transpired before the court. In the court, there was a petition filed by you and along with your wife for a divorce under mutual consent.
Even now, I'm ready, my lord.
Then where is the question of back out? You have only
Sir,
said,
after that, the court.
you have only said that
Yes, sir.
you are not interested in proceeding. You could have said that.
I told
You wanted that certain corrections in
I
that.
told that, sir.
That is not reflected. Both the parties are present. Second petitioner reported he was not interested
Sir,
in
and
proceeding
my
further.
lord, after fifth, I attended continuous 7 hearings, my lord. No one had come, my lord. Then the case got dismissed. If you see the CA application, they were not present, my lord. I have the original CA.
No, why would they remain present every time once when you say that you are not interested to proceed further?
I told
How
them
could
to
they
change
do
the
it
chief, my lord.
on
I
their
told
own?
them To change the chief, my lord. Nothing else. I'm even now ready, but the chief was literally.
You could have said that before the court below.
I will inform him also, lord. I will inform even his lawyer, Avinash, my lord.
This is the first time he is bringing these new facts after he has been put in the dock. Never he has filed a memo. He could have been filed a memo, my lords. Actually, have stopped him from doing that in the family court. He was very confident that once the case has been withdrawn in the Lok Adalat, he even circulated in the family circles, my lord. Once the Lok Adalat proceedings are binding, nothing can be done. He was in imagination that once the Lok Adalat withdraws, nothing can be done against him. But what he doesn't know the law, whatever has been obtained by the fraud will not stand to the scrutiny of the law. This thing might not have been given a legal advice to him, my lords. Whoever has given him the legal advice.
Wait. Can both of you not get the FCOP revived?
My lords, we are ready for that. I am not interested to prosecute him, my lords. I want to start a fresh life as a wife. If he files for the chief affidavit and if he is ready for that, I have no objections, my lords.
Just wait. What do you say?
Yes, my lord. I
You heard the other side, they are ready.
even
both of-
I'm ready, lord, but
Both of you go there, move an appropriate application seeking restoration of that FCOP.
but now the chief should be thinking.
That we cannot do. You will have to take appropriate steps there.
Okay, ma'am. Yeah. And, Lord, I would like to bring to your notice one thing.
Nothing. We are not interested in anything else.
Yeah.
This does not seem to be a proper stand on your part. Having got, see, if you have backed out from FCOP, in all fairness, the other matter also has to be restored. 498 proceeding. Both would have its own consequence.
Even I'm ready to fight for it, my lord.
Move an appropriate application, restoration of FCOP. Revise that same, Get a consequential order.
Give principal, my lord. And
That is what I said. You'll have to get an application for reviving that petition which has been dismissed. Because you are backing out of from that proceedings.
No, my lord, even in waiting.
We are going by the documents.
Okay.
Docket order says 13/12/2022, you said you are not interested to proceed further. Therefore, there has to be an application fresh on your part in reviving this and for pursuing the petition. So we will keep this pending.
So, my lords,
We will keep this pending. Otherwise, we have no other option but to allow and restore the 498A proceedings. So we would want that both the parties, since they have decided to part by mutual consent, move an appropriate application before the concerned family court, get the proceedings restored.
my lords, a month time may be given and suitable directions to the respondent too, so that we will be fully cooperating with him, my lords.
You will have to do it. Something has to be done.
I'm okay to do even after next.
Do it. You are appealing for?
For this point number 3, if I remember
For responding to 3? The mother. You are for the mother. So since he is representing your mother also, you can entrust him your power also so that he can take necessary steps in the application. You need not come every time from Bangalore.
In 3 years on.
That's what I said. By now it would have all been settled.
I have a problem.
Anyway, when do we keep it?
My lords, in the December second week, so that he get enough time of 4 weeks.
We will call it on the 19th of December.
Yes, my lords. Obliged.
And meanwhile, both the parties would have to move an application because it has to be jointly moved.
Yes, my lords.
You can get it up with Shravan.
Obliged, lords.
Lordship, I am for petitioner in this case, Lordship. The operation of law in 86A rule, sub rule 3.
The government has to make the permission, state government, department.
my lord, that as per rule, it was attachment was made. What's the rule of the?
No.
Yes, ma'am.
In terms of the rule, 1 year period has lapsed.
Not it. My lord, I look at the
2nd November.
second one.
The order of attachment is dated 2nd
November 2022, Lordship.
That's 2022.
Blocked.
Is it 2nd November or 2nd December?
Second December.
2nd December, only intimation, Lordship. Even till today, there is no notice under Rule 86A, which is mandatory.
My lord, there would be no notice under 86, my lord. There would be DSP under section 74 of GST, my lord. In fact, it was issued 2 days back, Saturday that has been initiated. He has given time until 26th November, my lord, for his reply.
No. When was the order of attachment passed? The annex of B2 seems to be an order of intimation.
Yes, Lordship. Page 21 is the ledger copy, Lordship. My petition, page 21. Page 21. It is a horizontal, yeah. And the starting date is 2nd November, Lordship, blocked. And after 1 month, they intimated to us, but it is not a notice, show cause notice. That is at page number 22, Lordship. It's only intimation, not a show cause notice, which is mandated under 86A rule. So it's a case of violation of principles of natural justice. And may I draw your kind attention to page 33, Lordship?
They are referring to a judgment, my lord, that would not be applicable.
No, not that. We are going by the provision.
86, my lord.
Provisions of law. 86A, sub rule 3, Lordship.
Such restriction shall cease to have effect after the expiry for a period of 1 year.
From the date of imposing such restriction. And the restriction was imposed on 2nd November last year.
Where is he getting the date, my lord?
You get it, page 21.
Page 21, Lordship. Page 21.
For which the ITC is claimed has been blocked. That period.
Blocked, yes. That is a restriction.
21. Hello, this pertains to the amount of block and block credit that.
So according to you, when was it attached?
My lord, on 2/12/2022 is from the date of the intimation, my lord, the date starts running, my lord. On 2/22. This 21 only refers to, my lord, the period on which, for which period the ITC is being claimed is being attached. That's not the date of attachment. In fact, it doesn't refer to any specific date. It only refers to 1 month period.
May I submit, Lordship? Even page 22 is not a notice under 86A, only an intimation that it is blocked. And that is a mandate in 86A. 2 times the words are used, having reasons to believe. No reason is given, no belief is there. And that too in writing they should give at 86A 1D, Lordship. The registered person, yes, Lordship. For reasons to be recorded in writing, not allow debit at so and so, Lordship. That there, even till today, there is no 86A notice. They have arbitrarily done it and they are only intimating, that's all. And we have furnished all the documents required 11 months back, Lordship. Now, December and January also. And we are suffering, Lordship. This is 25 years old firm. We have taken bank loans. Employees' salaries are held up.
May I submit?
Yes.
Before that point, Lordship, at page number 33 of the judgment of Gujarat High Court, paragraph 14 is analyzed well, Lordship. If your Lordship permit, I'll read out.
Yes, page number
33, Lordship, paragraph 14. The print is a little small, kindly pardon. That came like that. May I read out, Lordship? Very well analyzed with this paragraph. This is 86A by the High Court. May I read it, Lordship, for your convenience?
Identify impact under the judgment, my lord. At page 20, 34, paragraph 20 is the principal enunciation.
I am reading paragraph 14 at page 33, which is the essence of the judgment. Rule 86A has 2 prerequisites to be fulfilled before the power of disallowing of debit or suitable amount to the electronic rate ledger or blocking of ECL to the extent of the amount fraudulently or wrongly availed of is exercised. The first prerequisite is of the competent authority or commissioner having been satisfied on the basis of the material available before him that blocking of ECL for the aforesaid reasons is necessary. The second prerequisite is of recording the reasons in writing for such an exercise of the power. From the language used in Rule 86A, it becomes very clear that unless both these prerequisites are fulfilled, the authority cannot disallow the debit of the determined amount to the ECL or cannot block the ECL even to the extent of amount found to be fraudulent or wrongly availed of. Till today, there is no notice, Lordship. Only intimation is there at page 22. That cannot be considered a notice under 86. There is no reason given. And subsequently, we submitted all the documents. Even till today, they have not formed any opinion.
Which is that matter in which Dominic had argued in the morning. There was this central government notification circular which was referred to of 2021. Yeah, first half. Morning itself. Item number 4. Check in the bundle of item number 4. There is a circular of the government.
I think the
Where is the bundle? Bundle. Yes, yes, Mr.
I refer to page 26, my lord. Why it is that action was initiated, my lord. The genesis for this action, that page 26. This is the letter written by the central department to the state department. My lord, this office has took cases of fake invoices and evasion of GST against the so and so and so and so who created fictitious forms and issued invoices without supplying goods and facilitated in availment of input tax credit by over 200 different companies. They were reporting the company approximately rupees 67 crores, my lord. They have given a list of companies, my lord. Based on this, my lord, the page 28, my lord. Page 28, the addition of additional commissioner Chapman region is invited to the service and association. These are the cases, the bogus forms which have created GST and they have started issuing fake invoices based on this. ETC was available. This items 8 and 9, 11. These are the companies, my lord, referring to this, my lord. The impugned orders, my lord.
So you must have passed an order of attachment.
My lord, this
Provisional.
my lord, this is the attachment order, my lord.
Which?
My lord.
Page 26.
This is the intimating, my lord. In fact, 86 is only with respect to attachment, my lord. From here, 1 year time is given to the department to initiate appropriate steps. They have to, whatever the provision they want to deal with,
under that provision, they have to initiate the action, my lord. Under this, within this 11 months, my lord, unfortunately, State Department has not initiated any action. But on Saturday, my lord, they have initiated action under 74, my lord. Until this December, my lord, until December 2nd, my lord, they have time to conclude that proceeding. If they are not able to conclude that proceeding within 1 year, my lord, they have right of this default.
No, that is what I said. If you look at annexure P1 seems to be P2. P2 seems to be only an intimation, notice of intimating received fraudulent ITC from various dealers.
My lord, even though the getting the nomenclature, my lord, reads as intimating. My lord, I look at the order.
Yes.
This is to inform you that during investigation, the certain dealer has availed ITC without receipt goods against invoices from the following dealers from so and so. So and so hereby informed that during investigation of such dealers and mentioned to prove that these forms are bogus forms. And this office is hereby blocking the ITC from those forms against the fake invoice received as follows. Is affirmatively, my lord, that saying that they are blocking.
No, if you pass an order of attachment, there has to be a specific order to that effect. That under so and so rules, we are hereby issuing the order of provisional attachment. You are hereby being intimated to file your objections or comments, whatever it is, within a particular period of time. Where is such a correspondence?
Rule has not been mentioned by law, but under GST there is certain forms for each and every action. There are certain forms, my lord. For 86 variants, there is no specific form as such because they have issued these things. My lord, next page, my lord. Next year, I will say tax of so and so under GST. You are here to explain the reason for. I will myself, my lord. My lord, the only thing in this notice is, my lord, they have not mentioned that specific 86A subclause 3, my lord, except for this informative, my lord. But all the reasons, because the reason they have explained, but on what material they have tried to raise that account.
No, that also would be not difficult to accept because if you read page 20, contents of page 21.
Yes.
That again is blocking.
This is the block ledger for the period for 1 month period.
So it was already blocked.
Yes, Lordship.
It seems to have been further continued by the annexure P2 212.
Yes, Lordship.
Because if you look at paragraph 3 of page 22.
My lord, further, before saying, my lord, there was further communication, my lord, because this fake analysis and fake production has become
we do not want to go into the merits of the case because last time also we said that if 2nd of November is considered to be the date of blocking as would be reflected from page 21. Which stands
even by this date is also, my lord, this is 26.
No. That is the date, no, with effect from period from 2/11/2022 to 2/12 that you have blocked.
That cannot be the date for the initiation. My lords may even look at this date also, that would be 26/11/2022. This, my lord, as my lords are aware, every month GST upon returns are filed, my lord, and GST are 2B that ITC is populated. Every month it's reflected, my lord. My lords, for example.
No. We may accept. We may accept your
assessment period. This assessment period they have given 2/11/2022 to 2/12/2022. Even going by this page 21 also, my lord, that could be 26/11/2022. My lord, even going by that date also, the department has some time. In fact, they have initiated action. They have issued DS1 as contemplated under section 74, my lord. My lord, this is a case, my lord.
No. Do you mean to say that there will be no order of a provisional attachment at all issued?
My lord, In fact, this is the order, this is not in fact in a very proper format, but if you look at the purport of this order, basically says it gives the reason and why it is.
Nowhere does it talk of attachment. Nowhere does it talk of attachment. Look, if you look at the wording, you are only saying that hereby blocking the ITC received from those firms against the fake invoices. Then the next page, if you turn, you are hereby directed to explain the reasons for the availment of invalid ITC.
In fact, they are asking me reasons instead of they giving reasons.
We are not going on merit, we are not going on reasons also. What we are asking is
notice has to be given the reasons. Even DRC speaks about attachment and about the offense they have committed, and that they show cause notice has to be essentially issued for taking any action, any statutory action. My lord, we can't say that we will not give the reasons. These are the continuing, my lord. This order, my lord, per se, is not in proper format, my lord. But essentially,
not just, I mean, we could have understood if it is not in a proper. The wordings also does not say that it is attachment. That is the difficulty. How do blocking availing of ITC? Blocking availing of ITC.
Oh my God. Blocking availing of ITC, that's the reason. 86A, we talked about blocking of ITC.
No, but then you have attached these bank accounts.
No, that section 83 action has not been initiated. These are all in fact bogus forms, my lord. They on investigation recording done by the central government. They found that no such persons are found in those addresses. In fact, based on that, the central government, because these forms are all over India. So wherever the central government finds any investigation, if the supplier is in some state and recipient is some other state, in the recipient state they will give intimation to the concerned GST department. That state department initiates the action. So the recipient was in this state. That's the reason. This in fact the suppliers are not from this state. This is all over India investigation, my lord. So various bogus GST and registered persons were in this one tranche of transactions itself. There was the refund of 67 crores public money. My lord, in the last 6 years, my lord, the fake ATC refund was 63,000 crores. Last from GST, inception of GST, 2017 to 2023. My lord, it becomes such a menace, my lord.
What is the procedure to be adopted? Whether it has been adopted in this case or not.
My lord, this blocking has been done as per the rule itself, and the wording, my lord, as the my lord, it's not in a correct format, my lord.
Under what provision of according to you, under what provision of law is this order issued?
My lord, it's under 86 only. Rule 8. Attachment is under, now attachment of bank accounts would be under section 83 of GST. This is under rule 86A3, my lord. This is under rule. May reasons for recorded in writing not allow debit of an account equivalent to such credit in electronic credit ledger. This they would simply block that amount which their consideration has been wrongly availed, that would be blocked. And subsequently proper action under the uh, which are provision. Under this particular instance, we have initiated under section 74, wrongful availment of ITC, fraudulent availment of ITC.
Rule 86.
Rule 86A, subclause 3.
No, subclause 3 says that it would cease from to have the effect after.
86A, my lord, my lord's my lord, 86A, subclause 1. The commissioner or an officer authorized by him in this paper, they are not below the president commissioner and payments to be credit of input tax available in electronic credit or electronic bill. Input has been available on the strength of tax invoices or credit notes or any other document prescribed rule issued by a registrar has been found non-existent or not to be conducting any business from any place for which registration has been obtained without receipt of goods or services or both. This is the case, my lord. Without receipt of goods or services is the case of the respondent. The credit of input tax has been availed on the strength of tax invoices or credit notes, any other document prescribed under rule that is the tax charge in respect of which has not been paid to the government. The registered person availing the credit of input tax has been found non-existent or not to be conducting any business. May, for reasons to be recorded in writing, not allow debit of account equivalent to such credit in the electronic credit ledger for discharge of any liability under section 49 or for claim of any refund of any utility. This in fact, my lord, this attachment will only preclude the taxpayer adjusting this to the outward liability or seeking for refund until the process initiated under the GST is over. This will not secure income. Tomorrow, if he succeeds in this case, this MRT will be eligible to reclaim. This is only provisionally attached until the action is initiated. This is done under the investigation, elaborate investigation.
Correct.
Yes, my lord.
So that also would be after an order of provisional attachment is passed?
This, my lord, this office is hereby brought by it is a result. So that page 22, my lord, the notice heading says the intimation, my lord, but the wording of the notice says, my lord, here that they are also given the reason. The yes, India sponsor is hereby informed that during the investigation, certain dealers are mentioned below is to prove this bogus forms. They are given the attachment also, they are given the investigation report of the central government and so on which basis they are attaching this also they have supplied that documents to the
That's what I'm asking. There must have been an order of attachment as such.
Apart from this, my lord, this was the.
How do we call this order an order of attachment?
Without vigilance to the rights of.
No. I mean, we have been struggling for last 2 days only because the central government claims that this is an action done initiated by the state government.
This is the document, my lord, based on this. They are given reasons, my lord, they should have clearly said that this is a order under 86, rule 86A.
And it's almost, even if you take it to be put well, 11 months.
There is still time, my lord, they have initiated action. This is clear. Yes.
This was issued on 4/11.
For only after 2 days. Only after that night, I said, my lord, you are attached, but.
Save your skin.
My lord, even if the department, my lord, simply attaching will not do, my lord. They have to initiate the appropriate action under the act, my lord. Therefore, it is proposed to assess the registered tax for the tax. The registered register. Yes, you are right. I once look at it, 74, my lord. My lord, that is old act, my lord.
New one?
Here, but it's, like, GST. This must have been passed. Please, yes.
Central. This again is central.
TSHC Act,
My lord,
Telangana State GST.
my lord, both are except for one or two, my lord, CGST and SGST are same, my lord. In fact, speak about that. Thanks. 74, Robert, in fact, except for section 74. Well, or utilized by reason of fraud or any willful misstatement of computation facts, where it occurs to the proper officer that any taxes not be paid or short paid or erroneously refunded, or where input tax credit has been wrongly applied or utilized by reason of fraud or any willful misstatement or suppression of the tax to be made. He shall serve notice on the person chargeable with it, which has not been so paid or which has been so short or to mean the refund has been erroneously been made, or who has wrongly availed or utilized input tax credit referring to show us. This is the provision under which notice was issued, my lord. This is a
notice can be.
yes, my lord. My lord, this is a three-steps process, my lord. Notice will be even before issuance of notice, my lord. 73 is where there is my lord, tax is was paid, my lord. That has been done by mistake, my lord. 74 under fraud, my lord. Specifically, if it's done through fraud, section 74 is invoked, my lord. Wherein if the registered person pays the tax even before 74 is paid, my lord, the charges would be dropped. After issuance of PRC1, if the tax is paid, my lord, 50% interest and without any penalty, the charges would be low. After the hearing is over, my lord, under 10, then full 100% interest as well as full penalty has to be paid under section 74. This is the my lord. This is specifically for when fraud has been committed, my lord, section 74. this notice, as soon as they attach the notice, my lord, there should not have been any communication. Once that order, that adjustment has been passed under section 86A, one, my lord, they should immediately initiate action under 74 or 74 or whichever provision they want to rely on. In the instant case, 74. 74 they should have initiated, but so 12 months just before the period is being lapsed. Now they have initiated. They have to complete this action before the time. Otherwise, the attachment by default has to be unblocked.
When did the blocking started first?
My lord,
If we read 20, if we read 21 and 22 together, it would reflect that from 2/11/22 itself it is blocked.
My lord, the period for 2/11/2022 to 2/12/2022, my lord, that they are referring to 1 month period of 86, my lord. My lord, the date which we are referring is 26/11/2022.
So does it not stand blocked from 2/11 itself?
No, for that period, for every assessment period, for 1 month period, the returns has to be filed under TSHC. For this 1 month period, whatever the ITC is there, that has been blocked under 26/11/2022. My lords, I will. This is the electronic credit ledger, my lord, monthly credit ledger. My lord, this case is wherein ITC was blocked, my lord, his GSTN was not cancelled. He can do his business except for the purpose of claiming refund or adjusting this ITC for with his output tax liability. Other things he can do, my lord. My lord, surprisingly, my lord, he is saying that he is doing business for 25 years, my lord. My lords may come to last page, my lord, the very last page, my lord. Again.
Last page of?
The last page of this compilation, the very last page.
Yes.
The end of page. My lords, may look at column 18, my lord. Column 18 is the month it was blocked, my lord. 26/11/2022 is the date on which it was blocked. My lords, subsequently, my lords may look at my lord. He has stopped doing any business. These are the ITC claim every month he has done. Every month until that day, there was in lakhs of rupees, my lord. Thereafter, it fell to few thousand rupees. My lord, if it was a genuine business, my lord, blocking of unblocking of ITC, it's irrelevant. The business would be going on. My lord, absolutely, the business has come to standstill. In any cases, my lord, wherever the ITC disputes are there, my lord, ITC is blocked, my lord, the business will not stop, my lord. The ITC can claim for adjustment to his output tax liability, but that will not preclude him from doing his business. This clearly demonstrates, my lord, this business, my lord, is purely for doing this kind of transaction, my lord. Claiming based on fake invoices, fake e-challenge, my lord. They are claiming, my lord, lakhs of rupees every month. The modus operandi, I'm not saying in this case, my lord. The difficulty is, my lord, of modus operandi is, my lord, somebody in some state they will create fake invoices, my lord. Based on that fake invoices, they will file GSTN returns. In GSTN, they will not pay any tax. GSTN 2B that is populated, ITC would be reflected because that's system generated. Once they file returns without paying any amount also, that's populated and shown in 2B returns. Based on strength of the returns, the person, the registered dealer who is filing his 3B returns will claim this 2B ITC and adjust to his outputs tax liability. He would be really paying this, but he would not pay any amount. He would be adjusting this input tax credit and would be filing his return. And the C person, my lord, C person would be purchasing from the B person. Tomorrow, if you caught hold of C person, you will say that I've taken it from a rightful person, B person. Lord, B has genuinely has done that. But this was strength on the invoices created. That's how they claim all this ITs in the law. This, unless physically you go out to the location, you will not be able to find whether there is any business or not. And for verifying whether really goods has been traveled or not, the department asks for that lorry receipt, rail receipt, because the goods has to travel. Lord, apart from this, they have a e-tail kind of software where the actual vehicle has passed or not, all over India, they would be able to see that. Most of the cases, there would be no traveling of no movement of vehicle, my lord. In fact, if you look at this operation, my lord, the person, they will issue an invoice, money would be transferred to the person who is the supplier's account. That would be reflecting. Again, that money would be withdrawn and they would be doing whatever operations they would be. But in reality, there would be a bank statement. They would transfer. So when you ask for this amount, there would be invoice, there would be monetary transaction. Apart from the physical movement, the other documentary evidence would be there. This action has been initiated.
Howsoever corrupt the agency may be.
Yes, ma'am.
All said and done, you will have to follow particular norms.
Yes, ma'am.
How do you justify that?
Yes, ma'am.
That's
86 A1.
Yes.
My lord, that notice, my lord, the cost of preparation, my lord, that except for that heading, my lord.
No, even
not been very elaborate, my lord, but as submitted earlier, my lord, 86 money, they would not, they should not give any chance for explanation, my lord. Only after the appropriate action and the act has been initiated, then they will have proper surplus notice, then they will have the right of for 86 A, my lord, the reason is to be given as contemplated in this, my lord. Reason is
fair enough. If you take a decision that here is an order under 86A, you take a decision. Would you not intimate the other side that we have hereby initiated an action under 86A? You are called upon to give your comments.
No, under 86 money, as observed by my lords, reasons has to be given.
Yes.
But there would be, that would not be a show cause amount, that there would not be given any reason, they would not be afforded any opportunity to reply to that, my lord. That opportunity would be afforded only when under the appropriate section. This is only attachment. Under appropriate section, a show cause notice would be given under 74 section 74, DRC1 has been given. In fact, that's a show cause notice. He will have a right of personal hearing, he will right of argument, then a proper order under DRC 7 has to be passed. My lord. Once, in fact, if there was some back statements or something, my lord, under DRC 1, once the notice is issued, my lord, the department has right of attachment, bank attachment under 83, even for that 1 year. But in this instant case, my lord, there would be no bank accounts to be attached. There would be no person. In fact, there are non-existent. The person who has been. That's the reason this ITC has to block. Even tomorrow, if I want to attach this bank statement, there will be no. Under 83. Under 83, the GST department has power to attach bank statement. Well, only after the initiation of action under 74 only, he will write of opportunity for making his submission. He has to show us reasons opposing the show cause notice. Under 86 money, he will not, but reasons has to be mentioned for what reasons you are attached to that blocking the ATC, the reasons has to be given in 86A subclause 1.
That is also not there.
Well, one line reason not there given.
No, that is
During the investigation, mentioned it proved that these forms are bogus forms and this is
now whether this P2 is to be considered under 74 or 86A.
this notice that the P2 my lord,
Saying 86.
P2 will be under 86 A my lord. The notice right now given is under 74. That is TSHC.
How do you term it to be one under 86A? That's the whole difficulty.
This blocking can be only done under 86A and there is no other provision also.
Correct.
Yes,
But then there has to be an order.
yes, my lord. They should have mentioned it.
And then what is the explanation that was sought from page 23, the last part? If you say that there was no requirement?
Yes, my lord. Hereby directed to explain the reason for availment of invalid accuracy. This is the reply given by 24 page.
No. Under what provision of law has this been issued?
Yes,
If it is under 80,
they may not give this. In fact, they should not have called for any.
so that is giving us a rise as to whether this was under 86A or this was under 74 without codifying.
My lord,
If you are seeking his explanation, it could be under 74 also.
could be, there could be some,
74 only.
but attachment could not be.
Then in that case, the attachment could not have been done.
If it was under 74, not looking at the form and it was under 74. Attachment could not have been. Because that provision is under a different provision. Now, this is under no doubt that they have not mentioned it. The 86.
No. Question is, if it is under, let us assume that it is under 86. Then where is the need for seeking his explanation?
Yes, they should not.
So the content show that it is not under 86. And if it is not under 86A, even if we presume that it is under 74, then the attachment could not have been done by this order. And now 74, you have now issued another one.
Now, 74 has to be issued because
True.
Yes.
So then this, we presume it to be under 86. And if it is under 86A,
there was no
there
reason for us
seeking for explanation.
There was no initial right for it to. They were continuing with all this unnecessary communication. Thereafter, again, as the explanation I got in February, March of this year, and so there was communication. That was totally unnecessary. All those communication to and from.
So to that extent, this would not be sustainable.
Without the right to, for the department for taking appropriate action as kind of like because whenever they said
See, now that you have issued against 74,
yes, madam.
even without an attachment, you can proceed. You can proceed with that. This would not be sustainable.
Yes. These two are independent.
Correct. That's what I said.
Yes. Even without 86, they also that 74 can
you may proceed. This would be difficult.
With respect to 86, they also may not observe that as per law because once that is realized.
No, we will say that this does not. We will say that this does not appear to be under 86A.
Yes.
If it is not under 86A, you are right under 86 tax reserve. This has to go.
Yes.
Yes. which will be written later. We'll allow to that extent.
Yes.
Yes.
So that is.
Right, Lodge. I have obliged.
Petitioner is NACO infra, questioning summary order of GST DRC 07 dated 28/1/2023 for period April 2018, March 19, March 19 to April 19 to March 20, and April 20 to March 21, imposing interest under CGST and SGST. It is in violation of the principle of natural justice, as also contrary to the provisions of that and various judgments of the High Court. However, the notice was issued and the interim stay was accounted on 28/4/2023.
If I'm sorry, they can complete the audit by last and the
Counsel was the petitioner placed for time for filing rejoinder. Last time it was prayed that the petitioner wants to file some rejoinder.
So, I mean, they are supposed to file the counter.
Counter is already filed. You are taking time to file rejoinder.
It's not really get to me. I'm just.
Counter is not there.
Counter is not there, my lord.
Here's the number 55519 of 2000. 5/23, 2023.
USR number
55199 of 23.
55199
5/23, 2023.
23/6.
23.
The order sheet of 8/8, it appears there was a request made by the petitioner to file rejoinder, which means that you have been served with the counter. Though court must not have received the counter, but you have been served. That is how you are.
My lord, in fact, we also didn't got how is the counter get whatever the relevant information that has given. I would like to mention few of the points in the same matter.
Without the counter, what are we going to do?
I mean, with permission.
Neither do you have nor we have.
Okay, my lord, then next hearing.
Just check it.
Yes.
The request of the council for the department. For council of the parties, let this matter be on. When do we have it?
Any date in December, my lord.
28th of December. We can ready for you.
Sorry, Nathaniel, everyone.
Today. How much days? How much time?
1 week.
Council was the petitioner placed for time on the ground that the counter of the respondents have been served upon them only today. Split for time to get this case on the 7th of December. Yes.
34 to 38. The authority.
There was a mention made in the morning. The government had made a counter has been filed, not filed. Who appears for the petitioner? Who had appeared in the morning for him? No. Somebody else, the other person council had appeared. (34 to 38). The absence of any representation on behalf of the application will be listed on the 21st of December.
Okay.
When granting immediate additional action, directed the petitioner to take out constitutional assumption as fine. But I send the notices that issued, but no, there is no appearance.
No appearance?
No appearance with assumption. And file for service also. By memo dated 9/8/2023, I find the moment.
Waiting the appearance of the respondents, let this matter be taken up. Mr. Shashi, you are there?
Yes, not in appearance.
For R2?
Yes.
See, for R2, awaiting the appearance of the other respondents, let this matter be taken up on 19th of December? 19th of December, the interim relief earlier granted to continue. Let's see.
Apologies for matches in this. I am 33.
No, we'll mark it, 33, mark his presence.
The order says.
First is one.
Yes.
First.
42. But the order is not.
No, we are extending it. We are extending it. Two.
42.
Item number 42, P. Gangarami Reddy. None for the petition, raised this case in the, on the 20th of November.
43. It was for the selecting insurance.
Counter appeal is there? Counter appeal is there?
No, only appeal by claimants for only for enhanced.
Insurance company is not agreed.
Not paid any appeal.
Who appears for them?
Abstention was paid for Subbarav.
Today he was not there. Normally there. Anybody there on EPR? Item number 42. MACMA. 42. You are for the appellant petitioner. We have fixed it on the 20th of November. Mark his presence. Yes, 43.
Tomorrow will inform.
Not inform, you'll have to bring him. If you want a hearing, you'll have to bring him. You have to give him a lift also. What is the scope of enhancement?
Only Milord. Only scope where only income is the case of death may not. Disease who was here 30 years, the claimants are the parents of that disease. The claim will not two groups will not avoided only 54,80,000. The manner of accident to the demand disputed blood, the faithful damage, the disease proceeding as a two-way. At that time, the car dash with this motorcycle died on the spot. That is the manner of the accident. The insurance.
Income assessed is? What is the income assessed?
Income may not. PW 3 and 4 examined may not. The PW 3, who is the employer of the deceased? Examiner PW 3, PW para 20 related to that aspect. The total from issue number 2 million from I know para retake. That is original page 11. The running index 17. Maybe it may not be 18 from 18.
The date of accident is?
The date of accident will not. 4th September 2013. The deceased having qualifications after completing MBBS PG diploma in radiology, diagnostics, petitions have failed expeditions of excessive certificate. A8 passed that is the intermediate. A9 certificate showing that deceased has qualified in examination conducted was awarded degree of MBBS. My friend. That is examination graduate and the company of degree of MBBS work that deceased has attended these seminars and radiology and climate and character mentioned as good in certificates. The overall documentary evidence appears to be registration. It is evident that the disease was aged 30 years. By the date of accident, he possessed MBBS and PG diploma in medical radio diagnostics, and he was a merit student while prosecuting his studies. Now coming to the aspect of earning capacity of the disease, that the evidence of PW1 is to the effect that the sun rendered is valuable. That is that the further diagnostic.
Date of accident you said is 4/9.
Yes, 4/9/2013.
Exhibit X2
Yes.
is a debit voucher of 16th of September, that is much after the death.
The exhibit to A1. A1 FIR complaint dated about 5th September 2013. The date of accident mentioning 4th September, the FIR lodged on 5th September.
The page 20, para 20, middle portion.
The creation of examined that they will see
Middle portion,
middle portion.
where you find an amount of 2 lakhs. Just beneath that, he has filed exhibit X1.
Yes, that's right. X1 direct copy of Aadhaar card exhibit X4 debit voucher dated
16/9. So this is after the death of the deceased.
Yes, sir.
Though it is month for the previous month, but this debit has been made much subsequent.
Like joining in the job not after 29 only received one salary. After joining after 29 days, he emerged in the accident died me. The PW4 also will not confirm is another offer letter. That is para next para 21.
petitioner have examined Dr. Anil Kumar Patnaik as PW4. His evidence is to the effect that he has been working as central head in Apollo Clinic, Badhampur, Odisha, states from 11 August to 12. He met the deceased on 23 August 2013 and requested the deceased to visit the said Apollo Clinic at Badhampur. He has further stated that deceased visited the said clinic and agreed to work as radiologist in Apollo Clinic, Badhampur. Another PW4 has issued a 19 offer letter agreeing to pay package of 24 lakhs or monthly 2 lakhs. But the PW3 already given below 1,50,000 and 1,50,000 not casted by the tribunal.
For the said reason.
The tribunal observed Millard observed in para 23. Para 23.
No, para 20 itself at the bottom, 5 6 lines. Para 20, 6 lines.
Para 20.
In his cross examination, PW3
in his cross examination. About 2 lines also, Millard. Exhibit X5 is the certificate dated 11/12/2020 issued by him stating that deceased was paid 1,50,000 as salary for the services rendered by him for 29 days from 6th August 2013 in his cross examination.
This again is erroneous so far as exhibit X2 is concerned, where you say that there was a debit of 1,40,000.
Yes, sir. 1 lakh. There are 29 days they paid 1,40,000.
Exhibit P5 is the certificate issued by stating that deceased was paid 1,50,000 for the 29 days from 6/8/2013. There is some element of doubt. Then further down the same paragraph. In his cross-examination, PW3 admitted that
PW3 admitted that he has not got any document or record show that the deceased had accepted the offer given by Bhadra Diagnostic and to show that the deceased was appointed as radiologist in Bhadra Diagnostic Center.
Next line.
He has further stated that
he did not maintain.
He did not make
the salary register, the muster rolls.
At that time and at present he has been maintained on those records. He has further admitted that he has not paid the income tax returns related to Bhadra Diagnostic Center to show that he has paid 1,50,000 to the deceased as monthly salary working as radiologist. He has admitted that he has not deducted.
That's enough. That's enough. How do you come out of this finding? Yet the court has accepted 50,000 as his income.
Only below the capital estimated 50,000 per month. Not the observation given in paragraph 23.
Hear me, council. How can you help your friend?
If there and observed majority X2 to X5 all are applicable to the accident only.
He was a doctor with PG.
Maybe, but that
Look at the salary that is being paid to a doctor who is just a degree holder, MBBS. But with a PG, definitely 50,000 is too less an amount for a PG holder.
may increase reasonably, but not as treatment by.
No, no.
1,50,000.
That is why we asked, how can you help him? We were not accepting his contention, so we said,
70,000. Because what he is getting future is covered with the transport.
no, that is there. The court has taken 50%, to that extent is there. But then 50,000 does not, it's hard to accept.
And you discussion. Is one guesswork. You have to forget some guesswork. That's the absence of any operator. And you
We take it as 3,000 rupees a day, 90,000 rupees a month.
but take any amount, but.
No, not, I mean, it should be reasonable.
Reasonably long.
For a PG doctor, 50,000 is definitely less. And not even 2,000.
50 he told, 25 increase 50%, it is 75. Accordingly, it can be written.
Present is an appeal seeking for enhancement of the assailing the order dated 31/10/2016 passed in MBOP 2119 of 2018 passed by the MECT on 10th edition Chief Judge City Civil Court Hyderabad. By the intent of what the tribunal has awarded a compensation of rupees 54,80,000 with income at the rate of 8% till the from the date of petition till the order of the tribunal. we are accepting 50%, even though there is no regular employment as such.
This definition will not 1 lakh will not maybe considered will not.
50% is
MBBS will not completed PC.
personal expenses, the amount would come to 6,75,000. Which if multiplied, applying the multiplier of
17,
that is correct.
17.
17, it would come to 1,14,75,000.
For granted, 1 lakh for last of estate, it is around 15,000.
It will be in addition to the aforesaid amount, the claimant would also be entitled for PDL compensation of 40,000 into 2, 80,000 plus 30,000 towards loss of estate and funeral expenses. Thus bringing the total amount of total compensation payable at rupees 1,15,85,000. Yes. Double. Literally double. More than double.
By so many right to the
No, that's not. As long as you are there to support the petitioners, we don't have any difficulty. When to have it, yours. That's unfortunate. Unfortunate. And radiology is one of the most sought after being as on date. What about you? When can we have it? You come from? We don't know tomorrow who is there for the other side. 49. You are there. We can have it tomorrow.
Anytime after 11,
That would be our prayer also. After Diwali, give us a date. After Diwali.
Only the initial petition is small miscellaneous petition. See, branch same case. I take only few minutes, man. For this, almost every day it was being listed. It is unable to reach. Therefore, it will be posted after Diwali.
Since you have waited from 2021, you can wait for another 10 days. We can have,
now reaching.
No.
Mine is only 2,200.
We can have it on 16th. 16th we can have it. 16, 10:30, just make a mention. We will try to take it up at 2:30. 16, 49 at the request of the council for the petitioner and the responding council. This case on the 16th of November. 16th.